Welcome all of you. Hi, Lisa. Today we continue the final day of the first week of this block of 2 weeks hearings on the priority areas of child protection system and the criminal justice system. Before we start, I'd like to ask Commissioner Hunter to do a welcome to country.
Thanks, Chair. So I acknowledge that we are on the lands of the Wurundjeri and pay my respects to Elders, past, present, pay respects to those that have come before us to enable us to have voice here today, and may Bunjil watch over us as we conduct Aboriginal business today. Wominjeka.
Thank you, Commissioner Hunter. Council, may we have appearances, please?
Thank you, Chair. Commissioners, this morning we have a panel comprised of representatives from organisations engaged in the early years childcare system, followed by evidence later today from magistrates, particularly those involved in the Maramnala Gumbu program. We will proceed by way of panel this morning, and I will have each of the witnesses sworn in. Firstly, Lisa, could you tell the Commissioners your full name?
My name is Lisa Thorpe. I'm a Gunditj Gunai woman and the CEO of Pulpit Willem Aboriginal Child and Family Centre.
Thank you. And could you confirm that the evidence that you will give today is the truth to the best of your knowledge?
Yes, the evidence I give today is the truth to the best of my knowledge and the experiences that we've actually had through Pulpit Willem.
Thank you. Next, Stacey Brown, could you please tell the Commissioners your full name?
So my name is Stacey Leanne Brown. I am a proud Yoorrook Judjawurrung descendant. I am the CEO of Yapra Children's Service Cooperative Limited.
And do you mind if I call you Stacey?
Mm-hmm.
Stacey, is the evidence that you're going to give today the truth to the best of your knowledge?
Yes, the evidence that we have submitted today is the truth to the best of our knowledge based on the experiences we have encountered at Yapra.
Thank you.
Next, Kim Doe.
Hi, I'm Kimberly Doe. I'm a Yamaji Noongar woman. I work at Yapra as a family support worker.
And Kimberly, is the evidence that you're about to give today true and correct to the best of your knowledge?
Yes, the evidence is true and correct to the best of my knowledge.
Thank you. And next, Tracy.
Hi, good morning. Tracy Dillon, CEO of Nernda, a bachelor woman from Fraser Island. I'd like to acknowledge country, your elders past, present and emerging, and thank you.
And Tracy, is the evidence that you're about to give the true and correct to the best of your knowledge?
Yes, the evidence I'm about to give is true and correct.
And I'll just ask you to keep your voice up too. Thank you.
Okay.
And Auntie Hazel Hudson.
I'd like to acknowledge that I'm on Bunjil country and pay my respects to Elders past and present, and thank you for your welcome to your country. It's much appreciated. My name's Hazel Hudson. I'm the Director of Family Services at Nernda Aboriginal Corporation, and I acknowledge that the evidence I give today is true and correct to the best of my knowledge.
Thank you.
And I'll just go through your individual outlines of evidence just to confirm that you're happy with the content of that document and that's true and correct. Firstly, Lisa, you've provided an outline of evidence to the Commission.
Yes, I have.
And you've read that recently.
Yes, I have.
And the contents of that are true and correct.
Yes, they are.
Commissioners, the version of Lisa's evidence which will be tendered will be a redacted version on the basis that there will, at the close of this panel session, be an application for a restricted hearing in which some confidential evidence will be given by Lisa Thorpe. Stacey and Kimberly, you've got a joint statement. Have you both read that document?
Yes, we have.
And you're comfortable that the contents of that document are true and correct to the best of your knowledge?
Yes, they are.
Yes.
Thank you. And Tracy and Auntie Hazel, you've provided the Commission with an outline of your evidence,
Yes.
Yes.
and you've had the chance to review that. You're comfortable that the contents of that are true and correct to the best of your knowledge?
Correct.
And I note that there are some additional notes that have been provided by Auntie Hazel and Tracy, which we may give in the form of oral evidence today, or it may be in the form of a follow-up outline of evidence. Thank you. Now, I will follow the same order and just give you the opportunity to describe for the Commissioners and for the record what it is your organisation does. If I might start with you, please, Lisa.
Put Willem Aboriginal Child and Family Centre was established 10 years ago under the Closing the Gap initiative back in 2009. We started Boop on the same premises of what the multifunction Aboriginal children's services were, and followed that line of a long day care, kindergarten wraparound services. We have our whole program is based on Aboriginal children and their identity and who they are, and we've actually grown for the last 10 years and built up complete child and family services for our children that we control and we support, and we deliver all those services internally at Boop, including an NDIS ECIS service. We have our own allied health staff, a visiting GP, and we do a whole lot of support and identity program and servicing for our children on the ground at Boop.
Thank you. And I might just get you to talk a little bit about your own qualifications.
My qualifications are, first, my whole history has been working in the Aboriginal community in various different organisations. My longest history is working in the Aboriginal Health Service and did do some work at Yappa Children's Services in the early days. I then went to Deakin and done my Masters in Public Health and stayed at Deakin University at the Institute of Career Education and coordinated the Bachelor of Early Childhood degree, the Bachelor degree, and was there for 7 years. And then at that time we were developing Boop Willem on the ground. I was the chairperson and on the board that from the inception, then become the CEO in 2013.
Thank you. Stacey?
So YAPRA was established in 1981. So we've just recently celebrated 40 years as an Aboriginal early years service, which has responsive and really grounded holistic education and support services for our children and families. So as YAPRA has evolved over the years, it's important that we remain grounded. We are Aboriginal community controlled, so it's important that we remain responsive to what the needs, current and emerging, are for our families and communities as they do change each year. So we offer a range of education and care services for families around health, education and wellbeing, and they're holistic. So we provide wraparound services for all of our children and families enrolled throughout the entire service. Some of the programs that we do offer are art, dance and music therapy, which are really important foundational programs within YAPRA. Culture forms the foundation of everything that we do. So our philosophy, our vision, our purpose and our values, always, every program that we offer come back to those and ensuring that culture is the forefront of everything we do. We have a number of Aboriginal staff from the leadership right down to the educators in all the programs that lead the Aboriginal cultural component of the programs, as well as mentor and inform the non-Aboriginal staff that are working in our early years service. So we're very particular about the people that we do employ within YAPRA knowing what our cohort of families, knowing the cohort of families that we have. We have 100% Aboriginal enrolments within the service, and we currently have over a 2-year waiting list for younger children wanting and families wanting to access YAPRA. So we're currently unable to provide capacity to the number of children that are on the waiting list within our service.
And thank you very much. And could I just get you to tell the commissioners about your experience and background in this area?
So I have been working at YAPRA myself for over 28 years now. I went in as a young mum myself and the finance officer, so I came off maternity leave. Prior to that, I was working at the Aborigines Advancement League as undertaking a traineeship in finance. I then moved on to YAPRA, so I went into the finance role back then as a young mum, so working part-time. Then as we progressed, I moved into more of a leadership role at YAPRA, so I undertook my Diploma of Education at the time so that I could move through the service into the CEO role, and then I went on to do my Bachelor of Early Childhood Education at Deakin University when Lisa was there, and then got an honours in early childhood, so furthered my study. So I've been there in the leadership role since 2004. I commenced in 1994 at YAPRA, so it's been a long time.
Thank you very much. Kimberly, would you just like to talk about your experience in this sector?
So I started off in the primary school education when I was about 16. So from there, at that school that I was working at, there was a lot of children, Aboriginal children, enrolled at that primary school. So I've got my Cert 3 in early years, Diploma in Education and Care, and also my Certificate for in Community Services. And I've also been a kinship carer for my niece. So, yeah.
Thank you. Now, between you, Tracy, and Auntie Hazel, who's going to speak about Nurnda?
Oh, I will. Nurnda Aboriginal Corporation has been around for 50 years as of 2024 and is an Aboriginal community-controlled health organisation and provides a suite of services to people in the Echuca and surrounding area. Aboriginal people from the Echuca, Kyabram and surrounds. We provide social services, justice, medical service, health, social emotional wellbeing programs, and two residential services, the Baruna Youth Healing Centre and the Barimba Childcare Centre. The Childcare Centre was set up because previously there were only 2 places that were set aside for Aboriginal children in the community, and so the community decided that they would set up an Aboriginal childcare centre. The centre now is licensed for 50 childcare places. This includes 35 long daycare, 15 kinder, and it also provides a holiday program for children in primary school. At Barimba, we also provide services specialist services such as OTs, audiologists and speech therapists.
Thank you very much. And could you just tell the commissioners a little bit about your background and in this sector?
I have worked in the Aboriginal sector for a long time. whether that be on a board or the CEO of a community-controlled service. I've been the CEO of 3 of those, and they range from medium to large. I've also been the CEO of the Tasmanian Alcohol, Tobacco and Other Drug Council and the National Aboriginal and Torres Strait Islander Women's Alliance. And so children and women are at the heart of what I do. The reason why I went to work at Nernda is because I am interested in the healing space. I sat on the Healing Foundation in 2010-13, and so healing centres are very important in our communities because our people have suffered from trauma over the years since colonisation, and so healing, that's how I feel that I'm experienced in this area, and so I lend my skill set to supporting communities, assisting the Nernda community to have a child-safe environment.
Thank you very much. Auntie Hazel, would you just like to speak about your experience in this sector?
I've worked. I'm relatively new to this sector. I have worked for years, for over more than 20 years in grassroots organisations, and spent the last 10 years in Canberra, which is totally alien environment to anyone that doesn't belong in that land. I came back to Department of Department of Families, Fairness and Housing for 3 years, and then there became a position at Nernda Aboriginal Corporation with the Manager of Family Services position. So the CEO of the day, Carleen Dwyer, asked me to apply for that position, despite the fact that I had no life skills in community services. But what I had was I worked with New South Wales Aboriginal Land Council, who went through regular change. So I had good experience in change management, which is done me well over the last few years, because anyone who knows our arena since Roadmap 2 reform, through all the reforms that have occurred in our area, there's been significant changes that have happened within our space. I came back to this space because I firmly believe that when we have a privileged lifestyle, we need to pay back to our communities. So I'm working in what is substantially a very difficult space because it challenges who I am every day. It breaks my heart every day. But there are days when it fills my heart with joy. So is that good enough?
Thank you very much, and I just might note for the record that you also hold a Bachelor of Law and a Bachelor of Business.
Yes, but I don't hold that out to anyone. Thank you.
So I want to start with a bit of a difficult topic, and I would like to ask Lisa if you could just explain your experience with matters of identifying children as Aboriginal people and how they come into the service, into your service.
Okay, Booput Willem, the basis of coming to Booput Willem is based on your identity and who you are. We've actually put on our enrolment forms, along with all the other necessary information, is that a child, like who was your mob. We're not asking for confirmation of Aboriginality, we're asking of bloodline connections. 93% of the people that walk through the door know who they are at various levels of being very, very strong to not knowing much, but the people who come to Booput aware of their Aboriginality, and we either continue to keep on building their strengths, or we start to find we grow that through our programming. We actually have I actually think there's one child previously who's a non-Aboriginal sibling of Aboriginal children who will attend our centre. So we keep a family connection if it's relevant that we do so. But the children are coming out of the system is the biggest area where we actually have a lot of difficulty is when they're not knowing who their connectedness is to, and they do not have any capacity to find that out. And sometimes we'll have children sitting there for years and the department does not, whichever part of the department is, does not get back to us and cannot verify and identify the child, which then has an effect if they're there for years. They struggle because everyone else knows their identity in the organisation except for these children. Everything in the organisations, they have blocks with their names. We have maps that they can point to who their mobs are. Everything's built on the strength of their identity continually. And by the time they leave Boop Boop, these children are very grounded in knowing where they are on the map, who their mobs are, who other children's mobs are, and they identify themselves by their mobs. So it's all about their connectedness, their family strengths, and who they are. And so by the time they're going to schools, they are walking into schools strong and can identify and actually challenge the system about why you're not raising the flag or why you're not doing we call it acknowledgement to countries. So our whole program is based on the strengths of the child. We actually are very clear that it's not a cultural program because we're very clear we can't offer that, but we offer very strong abilities for these children to be able to connect, their families to connect and identify.
Stacey, is there anything that you can add to this topic?
No, it's very similar. So our policies align with Lisa, although we do ask for confirmation of Aboriginality upon enrolment. There are instances, those are hard to obtain because there are only a handful of Aboriginal organisations that will offer a confirmation of Aboriginality. Up until now, we've been fortunate. There are a lot of people, within YAPRA, either on the governance, so the Board of Management, or myself or staff within the service that know a family when they enrol in YAPRA. And we're very clearly, upon that stage of them engaging with YAPRA and during the waiting list process, are able to identify where the child is Aboriginal and who their mobs are, so where their family connections are. The issue lays with when we get children from the system or child protection that come in and enrol, and it's a process where we're not able to identify. So they're sitting within YAPRA identified as an Aboriginal child from the system, and we're working with the carers to then or the system to identify that they are indeed Aboriginal.
And that process of identifying them and finding their mob, is that something that your organisation is funded to do?
No.
No.
We're not funded. We often do the groundwork, so we're trying to connect families to mob or assist families with finding, or the carers, with finding who their mobs are. And it's not funded. It's a lot of groundwork and us speaking to elders or different people in community to try and link this child to mob so that they have a sense of identity and who they are, which is really important for YAPRA. As Lisa said, when our children enrol, we want to give them a strong sense of who their mobs are, who their families are, and that's what we do. We empower children so that they are going into school confident as to who they are as people and proud of amplifying who their mobs are, and we don't want to give these children a false sense of identity.
Auntie Hazel, is that Nernda's experience as well?
I can talk from both sides. So Nerndas require a confirmation of Aboriginality, but on those rare occasions when the kids don't, or if we know the family members, so quite often most of our kids are known by community. The children that are referred by Child Protection, they come via me, and I have a look at I require a genogram if they don't have a confirmation of Aboriginality, and I look at that genogram to see if I can identify potential Aboriginal families within that genogram. And we look at our genogram. So we've got a genogram for all our children that can cover that back wall with their family details quite often. So, and the reason we do that is a couple of reasons. Kids in child protection are traumatised from the very beginning. We can't afford to take on children that can't identify where their Aboriginality connection is in the event that they turn up. And because if we do that, we're working with children, we're accepting that they're Aboriginal, and then at some stage, historically there has been occasions when it's been identified that those children aren't Aboriginal at all, and so they've got to go through the whole process of de-identification, and they're being traumatised a second time. It's not our role to traumatise children. It's our role to support and heal them. So we're very strict with child protection in regards to the fact that if they can't give us a confirmation of Aboriginality or they can't tell us where that child's Aboriginality is, we tell them to go to the Finding Families, which is held by VACA, and link up to start doing that work around connecting those children back for us. You know, things like we've had children who were referred to us with a German name, you know, and most people would laugh at the fact that he's an Aboriginal child with a German name coming to us and they're supposedly Aboriginal. When I got their genogram, I didn't recognise anyone except there was one family that I recognised as being Aboriginal from Melbourne. And I went and confirmed that with our historian. So we're lucky to have Auntie Vicky Mitchell, who's worked with children all her life, so she understands a lot of the families, and Auntie Carleen Dwyer, and said, do you recognise this person? And they said, yeah, that's Auntie such and such. So we were able to take those families on. Those families are now connected to some of our biggest Aboriginal families in Swan Hill, Chukamoama area. So it's critical, given the level of trauma that they already have, and to ensure that we don't impose other traumas, it's critical that they understand that they're not accepted by Aboriginal agencies until they understand where their connection is, because we can do further damage to these kids if we accept them on face value. And, you know, the other aspect is that our services are small. We know that there's lots of Aboriginal kids out there that need that services. So we have to be ruthless to some degree to ensure that the kids that we do know are Aboriginal are getting that service that they need. I don't know if I articulated that well for you.
Thank you. I think you explained it well. What I hear from the answers is that the biggest problem is the kids coming from the system. Is there a responsibility, do you think, on the department to do better in respect of identification? Does anybody have a view?
The view that I actually have is actually that I'm not sure, because we also get all the stuff that you've said there about the department will bring children to us already identified, or they've identified, but with no evidence about that, and they're never questioned along the way about how they got that information or actually where it's come from. And we're finding there's a lot of times that they're getting from the non-Aboriginal component of the families, and there's never any reach into the Aboriginal families that they're saying who they're connected with, and so it just gets left. I think what we need to be saying is that how can people identify them without making that contact with the bloodline connection? That's why we don't accept, if people have got a confirmation of Aboriginality, fine, but there's so much wrong with a lot of them in organisations, or they're not doing them, or the accessibility to them. We know some organisations that are writing them based on I don't know what. So we actually don't ask that. We actually just ask, who's your bloodline connection? Because they're not coming to us with that information, which then department walks away and leaves it. Once once they get the children into care or into a support system, they will walk away and they don't come back. So I think the biggest part they need to do, they do need to make that connection straight up, or they shouldn't be approaching us because we're not equipped to follow that through.
So is it, in your view, is it just the department, or is it some of the the community agencies as well?
The community agencies, as in the non-Aboriginal ones?
The Aboriginal ones?
I don't really receive children from Aboriginal organisations or Aboriginal families who don't know who they are. It's mainly the children who are in the child protection system, whether they're falling under VACA, which is, I suppose, it's a community organisation, yes. If children in the system, and they could be coming from child protection, VACA, or these other agencies that sit outside of both of them, like Anglicare or Uniting Care.
Is that your experience, Stacey and Kimberly?
Yeah, so very similar, where often the children are coming in with a tick of the box. So it's just basically what the mother or has said at the time of birth. So there's no links being made. There's no genealogy being tracked when the child's at birth, when the mother has stated that the child's Aboriginal. So whether it needs to be done at that prenatal level with the maternal and child, prior to mum even having babies, there needs to be some sort of linkages made once mum's stated who dad is. So at birth, if it's the mother or the father that is Aboriginal, there needs to be the links, and there needs to be very strong evidence of what mobs that child's linked to at birth, rather than presenting at the service. And then, as Lisa said, when we put it back on department about doing the groundwork, it's just left. So it's left up to our organisations to then conduct the research with elders in community and go back to finding how this child may be Aboriginal and or Torres Strait Islander.
And I noticed both you and Lisa nodding when Auntie Hazel was talking about the need to be a little bit ruthless because of the limits upon your resources and not being able to spread them around. And that's your experience as well?
Absolutely. So for us, it's about identifying early, and we have to be ruthless because we don't want a process. These children are traumatised already coming into Yapra, so we don't want to further traumatise. Yapra is a safe space, and we're there to nurture children and raise them strong, and we don't want to do that giving them a false sense of who they are or not even being able to know who they are or what mob they come from.
I'll just add, we've had requests from, Department for Enrolment, and it's upon that initial conversation of us going, okay, who's their mobs? Is it from the mother's side, the father's side? And then the child protection workers are going, oh, we don't know. So it's us asking them initial questions, keeping department accountable for them to do their own work as well. Because we are finding that in some instances, parents are saying, yes, we're Aboriginal, but so many times they're just not following up or asking them questions.
Thank you.
Can I just add to that? There's mothers having babies. I mean, young mums who've actually are traumatised having in their own lives, who actually might be having their second and third babies, but the assumption will go that maybe the first child was an Aboriginal child, and so everything after that follows. And that causes a lot of grief for us, is actually like they're coming in saying they're part of a family. When you look at it and when we actually question them back again, they're finding out that, we've actually got one child currently who's had 4 paternity tests for this 2-year-old child who's doesn't look like it's an Aboriginal child, who has a sibling, who actually has another child being born, who they want to put into Boop next year. But there's a good chance we're going to say we have to stop all the enrolments for these children while it's young enough so we don't re-traumatise them, saying that they're Aboriginal. It's also a risk is that what what can happen is that because they're coming to an Aboriginal organisation, it's adding to that. Well, if they went to Bull or to Yap or to Parimba, they must be Aboriginal people. So it's just how do we put it really clearly that if you don't have that proof of who you are, there's lots of things wrong with why we can't take that enrolment. But it's still that same thing about the pressure that gets put on you from the system, and all all the story they'll tell you about why you need to take this child immediately and rush it in. Then they leave you hanging, waiting for responses. Some children be put into Bull they don't see a work again for another 6 months, 12 months, or any follow-up.
Is there something you wanted to add?
Yeah, I do. It's Nernda's practice to push it back to the department to look at Aboriginality, confirmation of Aboriginality, and I'm assuming that that's due to resource because it's resource intensive. However, I don't agree with the department coming back to us and looking at people's Aboriginality. I think that's for families and family groups to decide that, rather than our departments who may provide us with inaccurate information because they haven't got all the information. And I can give you quite a good example of that. I worked here in Geelong, and one of the people in Geelong was an Aboriginal family, and they adopted a young woman, and that person was then assumed to be Aboriginal. So, you know, it has to be done by the families. The families have to know the linkages. However, we need to be resourced to be able to do that job because it can be very intensive, especially if they're not Yoorrook where we come from, where we're working in, the space we're working in. If they come from another area, then we need to know the people who come from that area, or they may come from another state or territory.
Thank you. I just want to move on, being conscious of time. One of the things that the Commission has heard a lot about this week is the increasing and sustained numbers of children going into the child protection system, and I'd just like to invite each of you to express some view about how effective the community-based early childhood care systems are in ensuring that kids aren't entering the child protection system. Would any of you like to open on that sort of discussion?
Well, we actually receive children from 6 months onwards, so they're not newborns. So when they're coming to Bull, they're already 6 months. But we don't. We've actually built up a group of people who have actually been talking about this whole process of maternal and child health in the Whittlesea area, and it's very well identified that when children are born in the hospitals, the people who get the notification of the child being born, just the birth notification, is an MCH nurse who actually has no connection or do not. In the 10 years we've been at Bull, we don't have any children referred back to Bull from an MCH nurse, and Whittlesea is a fast-growing Aboriginal community. It's also one of the highest areas of child removal, so I don't know where the children are going from after they're seen by the maternal and child health nurse or what's happening with them. But yeah, we don't receive them from birth, but the ones who gets notification every birth is an MCH nurse, and there's no connectedness there between us or between the Aboriginal community and the MCH program. There is no way to. I know the hospitals try, and I know the hospitals have the Northern Hospitals put a whole lot of work into play about how they protect these children, and actually have stopped child protection going into the hospitals and doing notifications on newborns. But there is a definite lack of what's happened from a child being born, of a mother being pregnant, actually, and then that whole process having the baby, and then how people are moving in and making assessments then.
So that period before 6 months of age, your organisation's not funded to provide any services in that area?
No, we're actually regulated. We actually don't take in under 6 months. It's 6 months upwards. That's just our boundaries. Yeah.
But once they come into the care of your organisation, if I can put it that way,
Yep.
how well equipped is your organisation to give the sort of wraparound services that a growing child needs and a family needs to ensure that they don't end up in trouble with the department?
Once they're enrolled in our centre, they get every support that we can possibly offer them, and one is the inner in the rooms where they've got above ratio educators, especially across the rooms. We also have an on-site health and wellbeing centre where we monitor the children. We actually do 2 health checks a year, and we support the children moving through. So we're monitoring and picking up and supporting our children. You know, there's even the early childhood world does not get enough supports of attention that what they see these children every single day when they're coming into the early years centre. So they've got the best eyes on these children than anybody else out there besides their families, if they're with their families. But there is no recognition given to our early years educators that actually they are well equipped to support and watch and see the development of these children and actually how can they move forward with that. So that's why we've become our own health and wellbeing centre, so we can actually then follow that through when we're seeing if there is issues or delays happening. And so from the time they're at Boop, they're monitored and supported not only through their developmental stages of growing, it's also about their health and wellbeing at the same time. And
if you do notice things that might alert you to some problems, is your organisation then able to act on that quickly? Or
if we see, and if we're talking about in the child protection process, is actually there's risk that we can see. The first thing we'll do is actually approach the parent. It's actually not jumping to a conclusion straight away, talking to the families or talking to the people about the situation, what's going on, and then working out from there. And actually there's a lot of times that we can work with families to actually change a behaviour or a process, or actually make people very aware that family violence. So the children will come to us, and whether they're babies and they're traumatised or they're upset, it's very telling that there's something else going on. And if baby's coming with marked or whatever, you can tell. But we actually go back, talk to the families first. If that doesn't work, or we also let them know we're going to notify, we're mandated to do so, and the family's aware of it. And so, or we tell the department, if we have to make the notification, we're going to tell the family we've done that. So they know that there is a complete link. And in some situations, it's actually, we've been able to work it out as far as what the family needs to do, make changes. It settles down, and they know that we're their support base, and they stay with us. And we've actually had children go right through Boop, and we keep the families out of the system by providing that service, because they know they're safe here at Boop than actually having a notification going to the system, and that's worked a lot of times for us.
Is that a similar? Can similar observations be made about children at Yoorrook?
At Yoorrook, definitely. So families come to Yoorrook because they have that connection and they feel a sense of belonging. We're Aboriginal community-controlled organisations, so straight away families feel safe. But not just that, we have a high level of Aboriginal staff working within the organisation. So we find that, if there is a challenge that a parent or a carer is facing, that they have that confidence and they've developed that relationship, and that's really important, the relationship our educators have with families. So they're developing that relationship with the families so that they do build up that sense of trust. The families have informal conversations, and they may then disclose or share things that they're experiencing. We've got Kim on board, who's a family support role, that families will come in. If it's not Kim or the educators, it might be myself. The families can come in and talk about a challenge that they are going through, and that we have worked really hard to develop our own internal list of resources or services that we know that we can then link families to, so that there is that early intervention and prevention. There have been a lot of issues that have emerged as a result of COVID, and we're aware of that. There was an increase incidents of family violence and removal of children. So it's for Yapra us looking at what we can do more broadly to support our families. So our programs change each year to support those families, and we look at what the current and emerging issues are. But one of the things we do pride ourselves on is those relationships that we do have with our families and community, that they can come to us and they can talk to us about the challenges that they are facing. And we will implement strategies straight away to support that family, thus reducing child protection intervention, because we know what's happening. But we also have the staff on the ground that are community members that may know information about the family, something that's happened on the weekend or something that's going on with that family that may give us a broader understanding of what's happening or why that child's distressed on that particular day. So it's all of that, you know, that groundwork that we're doing and the work that we're doing with families, but that trust that families have to come to us, that we feel really does contribute to the prevention. But we also know the informal arrangements that exist with our kinship within our families, where mom do go in and assist mum or dad, you know, and it might be the grandmother or an auntie or an uncle that go in and do some respite so that mum can have that weekend so that they can recoup and then work with the APRA. And that, for us, keeps kids with family.
Thank you. The Commissioners have heard evidence this week to the effect that in some cases people are fearful of raising matters with the department because that triggers a child protection response. And is it fair to say that from the support and trust your organisation develops with the parents and families that it's a different relationship to the one that Aboriginal families can have with the department?
In what sense? Sorry.
That people can come to you and say, oh, I'm having trouble with something without risk of intervention from the department.
So in that case, like Lisa already touched on, we are mandatory reporters. So if, you know, it's always good to have that open, trusting conversation, and again, support with referrals or advice on where to next, but also having that trusting relationship to say, look, this is a reportable sort of instance as well. You know, at the end of the day, we do have legal requirements, but we will always be honest with the families. And same, if we receive phone calls, we're always honest with the families as well, so both ways.
We do also have families that come to us with challenges where they may be fearful to go to department, because it does start that process when a notification is made. You know, for our services, we can access money for families to access childcare at no cost, but often families are fearful to go through that process. Mm-hmm. So getting a referral letter from an agency so they can get free childcare. They don't want to go through that process because they're scared that it's going to start a process of intervention from a child protection agency. So they would rather not have access to free resources for fear of that.
Thank you. Tracy and Auntie Hazel.
Can I respond to that question, or
because
we did, we collaborated with the University of Melbourne and the Loddon Mallee Aboriginal Reference Group, Department of Families, Fairness and Housing, to do an evaluation on the services that NERNDA provides to our children, and it was to look at how they how our services enabled our communities to take part in our programs to support our children who are at risk of entering into the system. And so there was interviews that happened. There were over 100 interviews. We also looked at our existing data that we have throughout our services and how Barimba and our health services operate to support our children and our families. The purpose for that was to examine the health, the developmental, the education, and child protection outcomes and the well-being of those children that utilise our services. And it was also to look at, to have an understanding about the early childhood programs that are offered within our communities, and how those programs assist our families to keep our children out of the child protection system. We did have some preliminary findings around that, and so some of those, and sorry because I've only been there for a very short time, so I do need to refer to my notes. The preliminary findings were that our services were effective, efficient, accessible and acceptable to and provided a culturally and physically safe space for Aboriginal families and children. The interviewees stated that NERNDA services were enabling positive developmental outcomes in Aboriginal children accessing our services, that the data that we collect needs to have some improvements because we have integrated service delivery, and so the delivery around those services or the data is not captured so that we can demonstrate how well we provide services to our children and our mothers, because it looked at maternal child health as well. And it also looked at our Cradle to Kinder program as well, because that's their favourite program. So we did do a study, and that was just the preliminary findings for now, and we've still to realise those. But some of the things that, on a practical level, that our organisation does in terms of working with our vulnerable families is how we support our communities and empower them, how we give them the knowledge base and the understanding of how to keep a child safe, how to provide them with those life skills of understanding what abuse is, how this affects our children and what are the consequences. We also provide training opportunities for our parents and our staff, and one of our staff members recently went through some training and said, as an Aboriginal person on staff, and said, I wished I had gone through that training because I would have been able to understand what abuse was in my family.
Thank you. Thank you, Tracy. I just want to ask you, Auntie Hazel, about the nature of trauma in the families that the kids are coming from, and there was Stacey mentioned that there's a real aspect of respite for some families to have their kids be able to have their kids in an appropriate learning space. Is there any observations you can make for the commissioners about that?
There's a couple, but I also want to talk to that other issue.
Yes, of course.
I think I spoke a little bit towards this on Monday. There isn't an Aboriginal person in this room or in this state that hasn't been affected by trauma, and we call it intergenerational trauma or DNA trauma. So when stories are passed down from family to family about police coming on to reserves for the sole purpose of removing children, and elders telling the children to run, and having a field of kids running like little rabbits, and you're seeing their heads bop up and down, and those children being picked up by white people and put into the back of a car and driven away while their parents and their grandparents are chasing after them, screaming out for the right to raise their own children. Sorry, but I have a tendency to cry when I'm talking about these things. Is one of the foundational forms of trauma that we've experienced over the years. Or, I have friends that was part of the stolen generation. I have an older man that tells me that as a kid, he would be made to go down the gauntlet. Now, the gauntlet, if you don't know what that means, is where all the kids were in that home all the boys in that home were asked to line up on either side, and the young person that did something wrong, like might have went and got a biscuit because they were hungry or something else, were told to run down that group of boys, and those group of boys had to have a stick, and they weren't allowed to pick a little stick. It had to be a big, solid stick that would cause them damage, and every single child, as that boy ran down that thing, had to hit that child over the back or on his body with their stick. That's running the gauntlet. And if they didn't hit, or if they didn't hit hard enough, then they had to run the gauntlet, and the same process kept going. So that's the type of trauma that we experience, as well as, other types of trauma around losing your home. So, and not being able to practice culture, to be told that your culture is bad and you can no longer speak your language and you can no longer practice your law. That all impacts on us on a daily basis on how we perceive things. To walk down a street and have a white person walk across the other side of the street because you're walking down the street and going to come up close to them. A few years ago there was a story about a young mum who was on the train and singing in country, in language, to her daughter, and she was accosted by a few. You remember this story, Lisa? It was on Facebook. She had a group of young men come up to her and tell her to fucking speak, sorry for the language, colourful, fucking speak the Australian language here. You don't speak that language, you're Australian, we speak English. To be told that our culture isn't valued within society, that is trauma, apart from the trauma that our children experience because there's been intergenerational trauma. There's been families that have been involved in the child protection system from one generation to another. They haven't been taught how to connect with each other, how to bond, They've been put into homes where they're fed, but they've been treated as slaves. You've got to do this. You might be fed, but you're not part of this. And if you're going to misbehave, then we're going to give you up. Constantly being rejected forms trauma. And yesterday, I always do a little practice with, or have started to do a little practice with some people. If you see Aboriginal kids or you see Aboriginal people in a strange environment, they're always tight and always on alert, looking for where they can escape. When they're in that reptilian brain mode, they can't heal. And our people live in that mode most of their life. And that's trauma because they've never been told or they've never experienced what it's like to exhale. I call it exhale, but it's when the body relaxes. We take a big breath in, and it's okay to be you. Our kids do that on country. That's why it's important for our kids to go back to country all the time. That's why it's important for them to run wild, because our kids aren't made to be contained. That's not where they learn. So I'm sorry, did I get a bit off track there, Tony?
A little bit, but it's very valuable evidence nevertheless. And the point that I was trying to expand on is that for some parents and children, there is some respite and relief in the kids coming into a daily childcare environment.
Yeah. Childcare centres are an extended part of our community, and they're usually the jewel in the crown of any community that is privileged to have a good, culturally appropriate childcare centre. Because what's happening in the home is lots of factors. There could be violence in the home. They could have mum who's got anxiety and so becomes heightened at the least little thing. So when they go into a childcare centre, the children as well as the parents get an opportunity to heal. Because in that childcare centre, they're surrounded by the extended family. They come into contact with cousins and uncles and aunties all the time. And in there, they're told on a daily basis, you're beautiful, you're intelligent, you're smart, you can do anything you want in this world. And they heal and they become resilient. That's what the childcare centre does for our kids, is that they give it a sense of identity. They go out bush and they learn what it's like to be in bush. Young men in there, some of our kids start to play the didge. They sing in language. Our kids do their own welcome to country when they have visitors come in. So they just have this sense of identity that's infused into their every being when they're in the childcare centre. And it gives them, and there's nothing stressful happening in there other than the fact that they might not have got nuggets and they wanted fish fingers or they got a curry. So in there they're surrounded by beautiful women and men that are there to attach, that shows them what attachment's like, that it's okay, what respectful contact is. And at the same time, then families, parents have an opportunity to relax. They're not having to be switched on all the time. They can spend some time with their own healing. We call it pampering, but to sit down and read a book or, to watch telly or to sit down and have a cup of tea without a child yapping at your ankles. And, that's what it feels like, doesn't it, sometimes, when the kids are constantly, Mum, Dad, can I do this? Can I do that? And they don't get a break with it when they've got anxiety or they don't get a break from it. So childcare not only offers the child an opportunity to heal, it also offers the parents or the grandparents an opportunity to heal and to have some pleasure time for themselves, which is really important that we pamper ourselves, isn't it?
Can I just add to that question? And that we actually, we're highly regulated in the Western concepts of an early years centre, but coming into Boop Boop, it's completely changed. It's a community organisation. Our families are comfortable. The organisation it follows on from the early the Maxes and from Aboriginal health, from growing in a space of Aboriginal community control. It's about who we are and how we look after each other. The centre itself, we not only the children enrolled, it's their families as well. And then when we leave, we still have contact with our families. we created our own transition to school program where we follow our children through, and then we invite the families continually keep coming back and keep growing and keep growing and coming back. And, you know, we actually have some family members that come in and do bits and pieces. So the whole place, although it's highly regulated and that's all behind the scenes, what we do is have a complete open space where there's an opportunity for us to all come together, look after the children. And there is no identification in the organisation about whether a child's struggling, a child's in the department, a child's this, a child's that. They all together, they all learn together, and we all be... So it's coming into the space and sharing in what Pulpit does. We don't let the department in the door. They come in. If you want to see, if a child does need to go and do a visit, you do it at the end of the day. You don't disrupt the child's day, and you don't do the visit on site in case it's not a great visit, or even if it's a great visit, the child can be quite distressed after being, have to go back. So we've actually gone back to the department and said, if you want to do anything with the child, you come at a certain time, you inform us that you're coming in, and actually then sometimes, or most of the time, if the child's going to see their parent, take them home. Don't bring them back. So we very clearly told people this is the child safe space, not your easy access to our children. And we've done our best to try and build up a strong work relationship with the department to actually respect these children's spaces and respect how we work with our families.
I do have something to your question around early intervention, whether the childcare centres had the opportunity to. Nernda we have a wraparound service, and we were privileged enough to have and Tracy's already alluded to, Cradle to Kinder. So Cradle to Kinder was an intensive family services program that was put into the Early Childhood Centre, or Barimba in this instance, when it was funded. It was funded for 3 years. It was a pilot program, and it was extended for a little bit longer after that. The program actually worked with families, and it worked with the early childhood, the maternal child health nurse, both at Nernda and at the Echuca Regional Health Service. So it took on families, young women that were pregnant, right through to kindergarten. So, and they had those partnerships with the maternal child health and the Echuca Regional Health Services. So they identified these young mothers that were pregnant, are potentially at risk of child protection notification under the unborn reports at a later stage. So unborn reports happen around, I think they happen around 26 weeks with child protection. But these women, young women, were being worked with a lot earlier than that. A couple of years ago, there was a review of funding, and DFFH, it was under a different name, but was essentially DFFH, as part of that review, determined that they wanted to get into early interventions, programs that prevented families or children from coming into the out-of-home care space. So what they did there, rather than investing or getting the government to commit to new funding, they collapsed existing programs. So they collapsed the Stronger Families programs, the 200 hours programs, and the Cradle to Kinder programs into the Aboriginal Family Preservation and Reunification Response Program and Intensive Family Services Program. What that meant then was that Cradle to Kinder was no longer there because it was the funding for it was pushed into another program. The criteria for that other program required child protection to already be notified and the child already to go into the notification, already to go into the child protection system. So it was already there. Whereas Cradle to Kinder took kids on before they were born, a lot earlier and took those women on, give them an opportunity to address any concerns that might be an issue for child protection, so that when the baby was born, and it worked alongside those young mothers, so that they never got any notification to child protection. So collapsing that program then into a program that required notification to child protection before the referral was made, or required notification or referrals through the Orange Door places and the community-based care child protection workers. So at some stage, so the programs are there now. There's only one program there where it doesn't require, we can accept walk-ins, which is the integrated family services. So the entry point has been decreased, and the expansion of child protection referrals was increased. So that was a very successful program where it worked with young mothers. Because one of the criteria for at-risk children is if their mother was part of child protection, then they're likely to come under notification, unborn notification, or if their parents were, then they're likely to come under an unborn notification. So this was a program that decreased those unborn notifications or the risk of those unborn notifications. It's now been lost to community.
Thank you. I just want to move on to a different topic. We've heard some evidence about the transfer of some decision-making responsibility through the Section 18 process, and I just wanted to give each of you the opportunity to make observations from your organisation's perspective as to the way in which the Section 18 function has assisted or changed or not the child protection intervention and removal of children into out-of-home care. Does anybody want to go first?
I can just speak from the knowledge that I actually have. I don't have much knowledge about what the Section 18 is. I do know what it is, but from what and we're not engaged in anything in what child protection does. Where they don't include us, we don't know what's happening. We don't even, the only time we know when the court orders change is when the worker changes, if we actually happen to contact again. But from the time that a notification is done on a child to the time when it gets to the point where it comes under the Secretary's order, is it? There's not a lot of work done, and we don't know much about what's happening. And then by the time it hits that end and the Section 18 decisions are made, we don't play any part of that. We just there's what I can say in that whole process is that from the time that they're at Boop to that time when that orders happen, there's not a lot of work done. There's not a lot of contact with the children. That we will get a phone call 2 days before a court case to say, has the child been attending and is the child presenting well? And that's as much as the child gets. So there's no active engagement to engage in any of the programs that are supposed to be happening for this child to be reunified with their families. They can't reunify them if they don't know who the families are. But there's nothing done in that time period, or very little done in that time period, until it gets to the end where it comes under a Secretary's order and the decision's been made what happens to the child. It's really, really vacant of processes in.
That's regardless of whether it's to the department or a Section 18 organisation?
Yes. We don't see a lot of work done in that period of time to make change to reunify or to do any work with the families. That's what we're experiencing at Boop.
Is Yapra got any observations that it might like to make?
So it's a very similar circumstance under Section 18 where we really don't hear until there's a court order variance about the child, or 2 days before, 2 or 3 days, in some instances 24 hours before an order being made. So we don't have a lot of involvement in the process. When it comes to reunification with families, so when a child is in a non-Aboriginal foster care placement, we look at what work the department are doing or how we are working with agencies or the department around reunification with different family members. So we see the experiences of children sitting in the system and bouncing from carer to carer while this process happens. So short-term arrangements where in one instance we'd seen a child who was placed with Yapra at 6 months old with various attachment issues and went into several care arrangements while agencies were looking for family members who would take on this child. We've also got a child who has gone, is in our kindergarten, second year of kindergarten, where they have exhausted all avenues of this child being able to be placed with family. So this child in particular has had numerous placements that have been set up. None of them are Aboriginal care placements, so this child will, they've not been able to successfully find any kinship arrangement for this child. The carers have been identifying since the child was born that they are too elderly. The child has a number of needs because they have a diagnosed disability. And all of the placements up until now have fallen through for this child. So identified foster carers have backed out at the last minute, which has placed further distress on the carers as well as the child that's attending our service. So the experiences for us have been limited into seeing any successful sort of links to family in the children that we've had at Yapra.
What role does your service play in regards to ensuring the emotional well-being of that child during that turbulent time?
Absolutely. So our role, we're working with the carers.
Yeah.
So in these instances, we've got amazing carers that are working with this child. So our role as an Aboriginal early year service is to nurture these children, and we know what mobs that they are linked to. So we're able to do that groundwork around identity and making sure that the child's strong, and they are. This little girl's very strong and she's going into school strong and confident. So in this instance, the child has got a link to who their mobs are.
And I say, from what I hear from your story, is that you actually provide them with a stabilising during a
absolutely.
time when they're not stabilised.
Yep.
Everything else around them's disruptive. Your service is solid.
Absolutely. So it's that consistency, and it's like you're saying, that amongst the chaos, and it's not just children in care, it's all children where there may be risk, amongst the chaos, our early years service is providing stability for these children, and that the nurturing and the care and the
genuine love.
Yeah. That auntie connection. So everyone that goes into Yapra, that children refer to them as auntie or uncle. It's bigger than that, but they get that stability throughout the day that they need.
And it may sound like the answer is obvious, but is a child likely to get that level of care and support in a non-Aboriginal service?
Well, I was going to say in this instant, the carers have actually, they were originally at another service closer to where they live, and this child started at Yapra one day a week. And it started as a tick your box, that cultural connection, the family connection. But these carers, from their own observation, pushed to send that child to Yapra 5 days a week because they felt the connection. The child felt the connection to the service, to the educators, to the children. The carers also noticed that the other children treated this child no different. They treated this child the same and as part of their own community. So, yeah, in this instant, sorry, I've gotten sidetracked because of that question, but yeah.
We support the carers because they are amazing carers, but they initiated themselves to have this child visit with siblings. Or they'll come on it. So Yapra have, one of the things that we have identified is the need to bring mob together so that there is that sense of connection to others. So we've hosted 3 camps over the last 12 months on country. Our last one was on Yoorrook country. We've had a camp in Healesville, and our last camp had 232 participants, so families come along. And it's important that our kids that are part of the system are coming along and are being able to connect with cousins and aunties and so forth. So on this camp, our carers are coming along and they're forging connections with who those kids' families are. So these carers now take the child to visit their siblings, and that's initiated by the carers, not by child protection, unfortunately. They don't see the importance on this child visiting siblings, which is really sad. So, and these carers do it themselves, and YAPRA make sure that happens. It's really important that our kids are maintaining their connections. So what Kim was saying, that child protection ordering this child to come to an Aboriginal early years service so that they have that connection to family, extended on to the carers seeing the change in the child. So they saw it themselves.
Thank you. I just want to come back to the Section 18 issue and ask whether there's any observations that Nirna can make about the effectiveness or otherwise of Section 18.
So we have a pre-authorisation, Section 18, which we call Wallayaka. That's a Yoorrook word. It means water children, because we're on the river and all our children's are little water dogs. And a water dog is a story from my own culture, where my grandfather used to tell me, don't get near the water, otherwise the water dogs will come up and get you. So we all have those sort of safety stories around that kept our children away from the water's edge. Our practitioners in the Section 18 process work very closely with the early years process in Barimba. So if we do a referral into Barimba for our children, and we quite often fight very hard to get the maximum amount of hours that we can, because there's only, 50 places that our childcare centre has, and the demand far outstrips the number of placements that we've got. But we, as a program, understand how significant and how important it is to have our kids going for our early childhood centre. So we fight for those referrals to occur on every time that we get a child within the kindergarten or bush kinder age, or even through our after school program, go through Barimba. There's regular contact with our practitioners and the child protection, the child care workers. So they're constantly contacting the manager of the services or the team leader of the services to see how the children are travelling, if there's anything that they need. Are there any issues that they're observing with their development, and what other services do they need? We hold regular professional meetings where the manager or the team leader are invited to those meetings to discuss the development of the child, and we also hold care team meetings. So the difference between professional and care team meetings is the professional meetings, all the professionals that are involved in the care of the child attend that meeting, and we discuss the development of the child and make sure that we hit our milestones as far as that child's development is concerned. And then the care team meeting, we bring the carers and the parents and the families in, and they talk about any issues that they may have as carers or as family members that they might need support with, and we identify any issues that we might believe still need to be addressed as far as the child's concerned. So there's constant, if not weekly, daily interaction between our practitioners and our childcare workers. Now, I understand these ladies, because they're in Metro, it's a lot harder with Newgall, but I won't get into that section. Certainly at a local level, where we're in the regional areas, it's a lot different, the practice of Section 18 with our childcare centres and our other services at Nernda. When we talk about integrated practice, we take that very seriously. So that's making sure that all the services that are available and that are needed by that child are wrapped around that child to give them the best possible, it's hard, isn't it? To give them the best possible outcomes in life. You know, we want them to achieve, and Section 18 aims for that. And we want them to grow up in culture, because we know that culture is fundamental to their social and emotional well-being and their identity. If they have their identity, they're the richest kids in the world. So we push for that every opportunity that we can get. And we know that our early childhood centre is the foundation of that building. So, you know, they set the concrete that everything else is built on for our kids. So.
Council, I'm concerned about the time, and I do have a question I want to ask as well.
Yes, so I can indicate, Chair, that I have two more questions that I wish to ask, and I'm intending that we would finish with this panel by midday, including the restricted evidence, if that's suitable to the commissioners. But the evidence from these witnesses has been voluminous. So a single question can get a lengthy answer, Chair.
Exactly. Exactly.
We're not complaining.
Yes. So if you'd like to ask the question now, Chair, I'm comfortable with the questions being asked as we go.
Okay. And thank you very much for the information you've given us. So many things all mixed up. But I note that some of you are early childhood educated trained and use that term. I notice that it's mixed with, you know, care and protection and all of those things. And I note that statewide bodies are funded at a different level and indeed legislated into part of how programs work. And I'm referring, Lisa, I think it's your statement where you talk about two statewide bodies, Aboriginal Childcare and Education. Do you think a statewide body can represent early childhood education properly to the state in the context of the way organisations are moving to operate, and indeed, hearing the cultural wrap that you have, the cultural programs with early childhood centres now? I mean, they seem to be linked a lot to the welfare era, and I'm just wondering if we're losing something. Are we not valuing the potential in the space that you've enriched now culturally in the context of early childhood education, and whether that's being represented to the state? Or do you have an early childhood rep when we're talking about Aboriginal frameworks to government?
My experience is actually between BACA is a child protection agency, and it cannot represent the early childhood world. It's a very different world. It's and VAI is actually only there to it's 3 and 4 year old kindergarten programming. They don't. I know they have people around the state who are early childhood reps, but they actually, and I don't believe they're able to represent what we do in our organisations about the value add that we can have to support whatever's going on. And actually, we don't sit at any state table because early childhood is not funded by the state. It funds 3 and 4 year old kindergarten only. So the state and any of the representation across the state does not include the early childhood area. We are trying to make that changes, and hopefully, and just now because of the Closing the Gap processes, which is also bound up in so much things that are going on with that, is actually now we actually have a state rep sitting on there in early childhood development. But that's still fresh happening. We'll make changes. But the state does not fund early years education as how we're registered. It's a Commonwealth program. Yes. At a Commonwealth level, Booput Willem is not even considered an Aboriginal organisation as far as the funding is concerned.
So do you network statewide as early childhood centres or not?
It's getting stronger now because Snake has actually started up the Thrive program, which because we've been talking about as a collective group of early childhood education centres, and there's about 6 or 7 of them out there. Some are old, some are Booput and Darley, which is Bairnsdale. They come out of the last Closing the Gap program in 2009, and now there's a whole lot of new other services coming up. I think Bendy or Ballarat's got one, and they're starting to form up, and we're trying to build a stronger network of early years educational centres and how we can support each other, because there's no representation for us as a collective out there.
Right. I'm aware of the Commonwealth responsibility. The reason I ask the question is that when there was a National Committee on Aboriginal Education, early childhood education had a seat at the table, and that meant every national meeting there was something discussed of relevance to the states. But thank you very much. I was heartened by hearing the cultural richness that you offer to the young children that come through your care and the challenges that you face. So thank you, Lisa. Thank you all for what you do in that space. It's very challenging, and it just goes on and on.
Chair, can I ask a follow-up question arising out of that? Can you tell me whether your federal funding for early child development is special funding for Aboriginal people, or is it a slice of the pie of a general program?
We get funding from the Commonwealth, and the older centres, as in the budget-based centres or the early max centres, they get funding as Aboriginal organisations.
Yep.
The newer centres, actually, like Booput and Darley and anything forward, is not getting any identified Aboriginal funding. And the process you're seeing is they've been mainstreamed and assimilated into the mainstream process as years goes on. Users sitting on transitional money now at the moment.
So, yes, YAPRA and all of the MACs, or previously referred to as the multifunctional Aboriginal children's services, have been transitioned across over a 5-year cycle, this being the 5th year, or next year it is, to the same model of funding that Booput Willem is on, which is the standard childcare subsidy.
Yeah.
And there was a pool of funds through the Commonwealth that was identified as Community Childcare Fund. And it was transitional money, and what it was for was all of the gaps, all of those extra services that we offer. So above education and kindergarten, all of those wrap around, whether it be health, wellbeing, or any other sort of services that we offer to families. We didn't all get the same money, and it was a slice of the pie. So it was identified as there was a component of CCCF, which is mainstream, and there is a component which is Aboriginal identified. As I understand it, the mainstream and the Aboriginal money is very different, and it's very different how it's reported against, but it tapered down over 5 years. So it was up to, back then, I think it was Price Waterhouse that worked with us all to develop a business plan of how we want to see and what we wanted to offer our services moving forward 5 years. And they determined the amount of money that we got, which was very small. So it didn't actually put any value on what we were actually doing. And then in the 5th year, it tapered down to almost nothing. So it didn't even fund a bus service for YAPRA by the 5th year. We have just been offered another 2 years of that funding, but it really doesn't contribute to the essence of what we actually do. I believe our services, all of our Aboriginal early years services and the child family centres, it takes us as managers to be resourceful and go out and find the money ourselves. We know what our families and communities need, and we work hard to write the small submissions to get some state money to then incorporate the programs that we need for our children and families. So the only Commonwealth streams that we receive are the same streams that all childcare centres receive in Australia, which is childcare subsidy, additional childcare subsidy, and Boobulp and Yapra have just recently got the tender for connected beginnings,
Department of Education.
which just complements what we're already doing. We were very, we made sure we weren't doing it. We were already doing the work, so we didn't want that to create anything new for us. We wanted it to complement what we were already doing.
And then the other question I had is that your evidence proves to me the imperative nature of the services you provide, but it's not clear to me whether there is a coherent pattern of services across Victoria which all Aboriginal children can access, or whether there are the individual services operated by you presenting here today. So is it a coherent statewide program, or is it rather depends so much on local community effort and so on?
Yes.
And I think on the ground, the programs are all strong in identity and strength on the grounds. How they're funded are very different and very fractured, and actually it's a hit and miss. And they're not. Early years is not supported. Early years is not supported in Aboriginal contents, and definitely not supported in a non-Aboriginal context. It's not a good area to work in for sustainability, and your longevity in that space is 5 to 7 years. So, you know, there is the strength in these services. We've actually maintained our staff and look after our children, and there's something to be said about Aboriginal people in the workforce to be built up, look after our own. We're up against it at every single level in what we do in our organisations, because it's just been stripped bare. And you'll hear that on the outside world, what's happening in the early childhood world as well. There's nothing there to support. And if that bigger world keeps falling over, it's going to be even more difficult in the Aboriginal early childhood world. How do we survive in this? And how do we sustain and maintain these centres when it's so fractured out there about how we're funded, and actually how we're recognised that we add value to what's actually is needed out there, especially in the child protection system?
Well, there seem to be a number of structural and systemic issues, funding and organisational, which are quite pressing, but I don't want to raise those here. I think we've run out of time, and I'm happy to come back to those at some later time.
So thank you, Commissioner. Are there any other questions?
I do, just around funding, particularly Stacey and Lisa, because I know you've got that wraparound service up there at Nernda. When an Aboriginal child that's in the department or has department involvement is enrolled, do you receive any extra funding for that child?
No.
Are you involved at any decision-making point, or even case conferences with child protection around decisions on that child and what's going on?
We actually call them when we need to know information. We'll call them, not necessarily involved in every one of them that actually happens within the system side of it, but when it affects Boobulp and what's happening there, we actually become involved in it then, but not technically and legally involved.
So do you fear, correct me if I'm wrong, you see the child every day, basically, and you're not asked your view regularly on the child.
No.
Do you see a child protection worker regularly?
No.
Do you see an ACCO?
No.
Thank you.
I've just got one small question. I really like what you've been talking about, this idea of sort of auntying on the front line with kids, and that bringing that all together. You said you're all, demand is outstripping your capacity. Would you take more children if you were funded to do so?
If we had the spaces, for sure.
If we had the resources and the capacity, absolutely.
Thank you. Thank you, Commissioners. Early in the evidence, Stacey, I think you said that there was a 2-year waiting list for enrolment in your organisation. So there's clearly a large demand, and is that the experience of the other organisations?
Yes.
And I'm not sure whether you can answer this, but if there was a strong investment in early childhood services in terms of coverage and supporting the existing organisations, in your views, would that have an impact on the, or is it likely to have an impact on the numbers of children ultimately going into out-of-home care?
I think I missed that question then.
So we know that there's a very large number of children going into out-of-home care each year, Aboriginal children. If the early childhood services that your organisations all provide were funded to a greater degree and there was greater coverage from other similar sorts of organisations across the state, would that have an effect on that overall number of kids going into care?
I think if the early years services were funded and supported and recognised for the work that they do and support, they actually would support children to stay out of the system. And we can already have evidence of that happening at Bulporp, and I'm sure the others do as well, is that how we work and support our children, our families, and even the family members connected to that child to stay out of the system. And I think the more and more strength that we get, the better we can do that. For sure, we can hold children out of the system.
Yeah,
Is that Yapra's experience?
Based on, yes, I believe that if we were properly resourced and working with the child and family earlier, so when they're actually engaging with the service and entering on the waiting list, and it may be before the child's even born. So it comes down to information sharing with our other Aboriginal community controlled organisations, being able to have all of that background information and knowing the child and the circumstance when the child enrolls. I believe very strongly that we would play a role in limited or no child protection intervention if we were properly resourced. Because at the moment we're doing the work with no funding attached. We're doing it because we want that child to grow up strong and we want them to be nurtured. And we want Yapra to be a safe space for the child and the family. So we do the work regardless of getting the funding or not. So we can only imagine the potential if we actually had the funding and resources to do so.
Thank you. And is it the similar situation for Nurunda?
Yeah, look, I think based on that study that we conducted just recently, that demonstrated that our early childhood programs are very important in this space. And if it looks at looking at those coping mechanisms, supporting our families to be empowered to understand what child abuse is, how to put in place different mechanisms to help support them in parenting, understanding what it looks like at an early stage, yes, it would go a long way.
Thank you.
And to include trauma as well, looking at trauma, sorry, I meant to add that.
I will add that each of your outlines covers a range of other matters, and the commissioners have the benefit of your outlines of evidence being tendered, and will take those matters into account. And so we may not have covered all the issues today, but they are before the commissioners. If there's any further comment you would like to make before we close, I can give you that opportunity now, or otherwise we can rely upon your statements.
I have a statement that doesn't necessarily relate to this. On Monday we were asked on what could be put in place to actually decrease the number of kids that are coming into out-of-home care. And what we've seen is a significant substantiation after intake and after investigation and response. I think that there potentially, and there was discussion around the grandmother who was threatened because the house was untidy and the child protection worker believed that it was dirty, and that placed the child at risk. I think that there's provision there at intake or investigation and response before they go to the court to have a panel of Aboriginal people where they take their evidence to that panel and say, this is the evidence that we've got that's we're going to rely on within the court system to place an order against this family members, and for that panel then to determine whether or not that evidence is sufficiently strong enough for that to happen, because that would certainly block grandmothers being taken because their house is untidy, and other what we might consider low-risk factors that are now getting kids in out-of-home care. So I don't know if this is the forum for that, but it can certainly prevent the number of kids being substantiated.
Thank you for that suggestion, and it's something that the commissioners can consider. Thank you very much.
Thank you.
Any other closing comments?
No, I don't have one.
Commissioner, I tender the witness outline of Lisa Thorpe in its redacted form. It's 5.1. The witness outline of Stacey Brown and Kimberly Doe, which is 5.2, and the witness outline of Tracy Dillon and Auntie Hazel Hudson, which is 5.3. And indicate that we will now move into a short closed session, and I'll seek orders for that purpose. Chair, do you have a copy of the proposed order of the Commission?
Yes.
The order that's proposed is that the hearing of the matters be led in a closed hearing whereby all members of the public parties with leave and all non-essential staff to appear are requested to leave the hearing room, and Yoorrook's live stream is paused, and the relevant evidence is omitted from published video recordings, and that a copy of the order is to be placed on the door and published on Yoorrook's website, and then there's a restricted publication order that the oral evidence and the part of the outline of evidence, which is confidential, be subject to non-publication orders. And if you're able to make those orders, Chair, we can move into that closed session now.
Thank you, Council. I make those orders in the terms sought.
We could thank the witnesses. Thank you all for your attending, and we would ask you to leave. Thank you.
If the Commission pleases,
Council.
I now call today's next witnesses, Magistrate Kay McPherson and Ashley Morris. Your Honour, do you undertake to provide truthful evidence to the Yoorrook Justice Commission today? Mr Morris, do you undertake to provide truthful evidence to the Yoorrook Justice Commission today?
Yes, I do, yeah.
Your Honour, will you introduce yourself to the Commissioners and explain your professional background and the current roles you hold at the court?
All right. Good afternoon. It's still good. Oh, yes, it is afternoon. My name's Kay McPherson. I'm a magistrate, and I was appointed a magistrate in 1991, so I've been a magistrate now for 31 years. Initially, I sat at the Dandenong Magistrates Court in crime for 15 years, but for the last 16 years I've been in the Children's Court. Prior to that, I was a criminal lawyer at Legal Aid, Victoria Legal Aid. I commenced at the Children's Court in 2008, and I'm very fortunate to be the Regional Coordinating Magistrate at the Broadmeadows Children's Court, and that court was set up in 2015 as a court of innovation. The features of innovation are Marinala Gumbo, the Family Drug Treatment Court, docketing, and a adversarial way of dealing with parents that come into our court. I'm the head of the Family Drug Treatment Court and head of the Koori Family Hearing Day, Marinala Gumbu, which I believe we're talking about today. Thank you. Oh, I might say that I'm not an Aboriginal woman, so sometimes I feel ashamed that I'm not, because I think that we white people have treated Aboriginal people in a very terrible way. But really, that's me in a nutshell. Thank you.
And Mr. Morris, will you introduce yourself and explain your background and the current role you hold at the court?
Yeah, thank you. My name's Ash Morris. I'm Gunj Maraman through my father, and my mum's from Ireland. My father's Ricky Morris, and my nan's Auntie Min. You may remember Auntie Min from down in Hayward. That's my family. I currently work at the Children's Court as the manager of Koori Services and Programs, where I look at making sure the court are delivering culturally appropriate service where we can, and look after our Koori Family Hearing Day, which we know as Marinala Gumbu. My role has evolved over the years. I initially started in 2016, where my role was to develop and implement Koori Hearing Day, which we now know as Marinala Gumbu, which Ms McPherson and I are here to talk about today. That's my current role. Like I said, I'm Gunj Maraman. I was born in Traralgon. I went from Traralgon to Brisbane to Perth to Wodonga to Melbourne, and I now live in Kyneton. I've got 3 little girls, and I guess the reason we moved around a lot was because my old man was in the army. But growing up, Dad was always involved in community and was chairs of Rajaks and Koori co-op, Mungabarina co-op up in Wodonga growing up. So I suppose my personal and professional life sort of was built well before me, with people before me.
Now, Your Honour, would you explain where the impetus for the establishment of Marinala Gumbu came from?
There are a number of reasons why Marinala Gumbu was set up. It had been recommended by a number of commissions. The Commission into Vulnerable Children recommended a Koori Family Hearing Day, and a number of other, and the Aboriginal Justice Forum had recommended it, and it had long been considered to be unnecessary adjunct to the Children's Court. From my point of view, as a magistrate, I believed that Aboriginal children were not being dealt with properly in the Children's Court, and the main reason for that was that parents weren't coming to court because of the injustices of the past to Aboriginal people. They didn't want to come to court. Their experience had been that their children were taken away from them or they were sent to jail. They were also distrustful of child protection, so they simply didn't come to court. So if Child Protection had taken their children from their care, I was left with a case where all I had was the information from Child Protection. I didn't have any information from the parents, and I assumed incorrectly that what Child Protection told me was correct. And I'm not saying that Child Protection deliberately misled the court, but they weren't aware, for example, that some of these families and parents were dealing with and addressing their problems through Aboriginal organisations, and I simply wasn't in receipt of that information. So I'd make, and my colleagues would make orders placing children or keeping children out of parental care when in fact they should have been able to go home because they had been addressing the concerns through Aboriginal-based services. So that was my great reason for wanting to support Marinala Gumbu, and I think the results have shown that it's made a big difference to Aboriginal children.
Mr. Morris, what locations does the day or the part of the family division now operate out of, and why were they chosen?
So our first location was Broadmeadows, purely because there was funding attached to the new build to try new things, and it was an environment where we could do things differently. We launched that in August 2016, and then 2018, we received some funding through the Aboriginal Justice Agreement Phase 4 to evaluate the program, which I think you guys have been provided with that evaluation, and an expansion for one rural location. We chose Shepparton for a number of reasons, and it kills me to put it this way, but there was the need for it. We did know that Shepparton, in terms of data, was behind other areas of the state in the amount of children in out-of-home care, but it coincided with the recent build of a new multi-level, multi-jurisdictional building. So we had thought that it would be easier to adapt what we learnt from Broady and take it to Shepparton, but there was some barriers in delivering it in Shepparton, just due to the way the Children's Court is set up in the regional locations. It's generally a magistrate's court-dominated location, so we kind of had to fight pretty hard to hear our voices, and we ended up employing Tina King, who's here today with us, who really put in the hard yards to be the community's voice and saying we want this here and this is how we want it, and making it happen. So a decision was made by our senior leadership to staff the family division centrally. So we have a magistrate who circuits up weekly to run the family division of the Children's Court in Shepparton from Melbourne in Magistrate Langdon. And that's our only two locations.
Right, and when you were first establishing Broadmeadows, Mr. Morris, could you explain at the very beginning how Maramnagala Ganvu was designed and how decisions were made about how it would operate?
Thank you. So I had come from the Magistrates Court where I'd worked in the Koori Court, the criminal division. My role there, I led the expansion with the team in Travis Lovett and Robin Young to expand the Children's Koori Court to all existing Magistrates Court locations. So that's sort of, I guess, where I learnt my craft. I learnt how to do things differently within a legislative boundary. So I come across to the Children's Court thinking I'll just do what I've been doing for the last 8 years and just do it in a new court, and I've got a pay rise, I'm happy. But I was pretty quick to learn that the family division, child protection, was a complete different landscape. The Koori Court is a sentencing court. It's post-proof. It's plead guilty and get into a situation. Whereas child protection, if we waited for proof, it would be too far in the child's life to focus on the importance of connection to family and culture. So I spent a lot of time with families, lawyers, local Koori orgs, and just really heard from them what we could do better. What we could do better as a court to get people in the door, because it was clear that the magistrates were making decisions on a one-sided story. The three things every family said was get rid of the magistrates, get rid of the lawyers, and get rid of the department. And they were our three non-negotiables. So we had a fair task ahead of us, Magistrate McPherson and I, but we pulled together a steering committee, which was made up of representatives of the local Koori orgs, local lawyers, legal aid, VALS, JIRA. And importantly, we had two community members who were there as community members to really guide us. So I was the voice for community, backed up by them too, that sat on our steering committee. And we took what we learnt from Koori Court and adopted it into the family division and come up with the adapted court setting and the case management approach. And we had to get cracking. We had too many families coming through the doors. It was probably, I don't mind bending a few rules, and it probably wasn't the best project management in terms of a project, just because we had to get it done. I just didn't have mob coming through the door, and it was resulting in bad outcomes. So we kind of said to the steering committee, thank you, everybody. We're just going to roll with it based off what we've heard and see how we went. And that's really how we got it up and running. And the same thing in Shepparton. Tina put together a steering committee, and we taught the community up there what we were able to achieve at Broady and said, this is your space, what can we do? And yeah, that's how we got it going. I should say, prior to me starting and starting the steering committee, there was some work done by some people before me. It was requested through Aboriginal Justice Forum in 2009 in Geelong that a Koori Hearing Day be made. So we did have a little bit of a model there, but it was 10 years after the fact, so we did have to modernise it, and off we went.
Your Honour has decades of experience with mainstream courts. What is different about a hearing and you conducting a hearing in Marram Nagala Gambu from mainstream court hearings?
It's very different from mainstream, although the principles are still the same and the law's still the same. There's no special, there's no different outcomes. But we all sit around a bar table. Have we got some photos
Yes.
of it?
If the operator could display the last page of the outline of evidence, which has pictures of how the courtroom is set up.
We all sit at the bar table, including me, and I think that's really important. If you could see...
And if we could zoom in maybe on the first one for the moment.
And the court is set up in what we consider to be a culturally appropriate way. The artwork is done by local artists. The possum skin cloak was done by a community weekend that Ash organised. The Coolum was made by a kid in ResiCare. And so it makes people feel more comfortable, so they say, which is good. So I sit somewhere around that round table. All the families sit at the table, including any support people they have with them. They don't have to be joined as parties. In the Magistrates Court, you have to be joined as a party to actually sit at the table. So we have elders, any family members that want to come along to support the family members in court. So they'll sit next to their lawyer, although sometimes I don't even talk to the lawyer, I talk directly to the parent, which I find more effective. And I start by introducing myself, and then we go around the table and everyone at the table introduces themselves. If there's anyone in the back of the court, I'll get them to introduce themselves too, just so that the parents know who's sitting in court listening. And then I'll often say to the department what they're seeking. And if they're not seeking for the child to be returned to the parent, I'll say, well, what does this mother or this father or these parents have to do to get their child returned to their care? And so a plan's often made. We have a lot of support services on hand. They don't necessarily sit at the bar table because we used to try and have them come every week, but it was too time consuming for them if they didn't get any referrals. But the Koori support officers are there at the table with them, and they help get them into court. They'll speak to them between that court hearing and the next court hearing. And the Koori support officers are vital in the process because they encourage the parents to come and they support them once they're at court. They greet them at the door, and that's really important. So the hearing just proceeds really in the normal way, except that it's a culturally appropriate setting for them. And I'm hoping that they would feel comfortable in that setting. And the evaluation that we've had says that they do.
Mr. Morris, just talking about what's culturally appropriate, what do you think makes that space and Marram Nagala Gambu generally a culturally safer place, accepting that the child protection system might not ever be able to be completely culturally safe, but for people than the mainstream court is?
It's just the top to bottom service we deliver at Broadmeadows. You can be yourself and your voice can be heard. So my team, our role is to get people in the door and get rid of all your anxieties before you get up to the bar table and be able to truly engage in the process. We also have Likijika, which is the access program who the department must consult with in any major case plan decision or the decision to remove and place child. They're at the bar table with us. And that extra support with the mobs through the cultural lens, that's where it comes from. Everyone's there to have that conversation. The art and things, it's all local. It's all people with, first-hand experience with the child protection system. So you walk in and you see your aunties painting, you just go, oh, thank you. Just the paintings alone. I mean, for some people it's art on the walls, but the stories really talk about what we're doing in this courtroom. And the Aboriginal people that walk into the building, they know that. They see the pictures and know that, okay, we're safe here, because me and the team have either met you at the train station and walked you all the way down through security, or we've been ringing you every day for the 2 months leading up to it, because that's what you've asked for, just to keep you across what's going to happen in the court. We also really, really focus on the process with families. They know exactly what's going on. And I suppose we kind of act as interpreters. This is what a subs is, this is what an FPL is, this is what the families, from the initial sitting to finalisation, they know the court process so well that they come back to support their family, because they're the voice for the community to stand up and say, this is my cousin, she's got some things going on, but we're going to get her through it. Whereas the old court was sit in the foyer, be ignored for 3 hours, go sit in the first row while two people, talk about you as a family to someone sitting up on a wall who just ignores you. That being able to walk through them 2 doors there and be able to sit up at the bar table before the decision maker and say, I'm Ashley Morris and I'm the father, is more than enough to get things moving.
Your Honour, did you or any other magistrates who were aware of the proposal have any concerns about being down at the table with the parties before you tried it?
I never had any concerns, and my colleague, Ms Hawkins, we alternate the weeks that we do, we've never had any concern. But some of our colleagues were concerned about the lack of gravitas in not sitting up on the bench. I don't believe in gravitas. I think if you treat people with respect, you'll get it back 16-fold. They were also concerned about safety. I've never had anything happen in Marinala Gumbu to cause me any concern whatsoever. So I don't think that they're concerns that I'm concerned about. But if my colleagues are concerned about it, well, I respect them, and they wouldn't be people that would be appropriate to sit in Marinala Gumbu. And I'm very mindful of that if I ever go on leave, to make sure that we have a relieving magistrate that does believe in this process, and because I don't want anyone to come into that court. I'm quite proprietorial about it. I don't want anyone to come in and scare the people away.
Mr Morris, anecdotally you've said that families are moving houses to get access to Marinala Gumbu. Do you think there is enough demand to run more lists like this in other locations?
Yeah. I don't know how to answer that. Victoria is the highest number of children out of home care, which I'm sure you've all heard this week. And we often get asked, why is Victoria, we've got all these great things, yes, it's only in 2 locations, but why do we have more kids in out of home care? And I think it's just because the applications come to us, and unless it's this approach where the true story is told for the decision maker, that's the gap. I've got confused myself with the question because it was kind of like, so many out of home care. Like,
do you think there's a need for a list like this in every kids' court, or just some of them?
Yeah, definitely, 100%. You read the evaluation, you hear the stories. We've got, my team. Just this morning on the way in, I had a call from a parent who accessed Marinala Gumbu 4 years ago, who's unfortunately back involved in court proceedings, not at Marinala Gumbu, at either Shep or Broadmeadows. And just the stress at the start of the call to the end of the call, when I said, it's okay, don't stress, your case has been transferred to Shep and we have Marinala Gumbu there, was just from up here all the way down to the bottom, knowing that they would be treated fairly as an Aboriginal mother in that court was just phenomenal. And it is the court's aspiration. We do want to deliver this statewide. It's just, how do we get there?
Your Honour, in 2019, you mentioned there was an evaluation of Marama Ngala Gambu undertaken, and it found that the court experience for Koori families has been transformed. And one of the biggest things you've mentioned is that families are more likely to attend court. The evaluation also found that families were more likely to follow the court orders that you and your colleagues have made. Why do you think that is the case, and how does families' compliance with your orders affect the outcomes?
Well, I think there's greater compliance because they're part of the decision-making process. They sit around the table and, for example, if the parents have got, say, drug and alcohol problems, we'll say, well, let's try and address the drug and alcohol problems, and we might refer them to Family Drug Treatment Court, which is another of our programs. And if they're not able to address those concerns, it may be that we can't return the children to their care. But we've given them the opportunity, and sometimes parents know that they're not going to have their children returned, but they've had the opportunity to be part of the process, and they've had the opportunity to know that their children are going to be placed in a safe place culturally. And I think the very fact that they're part of the decision-making, or not the decision-making process, but part of the discussion and the whatever's going on around the table makes them feel, well, yes, that's the decision, it seems fair, I'm going to comply with it. That's my experience of it.
And is your sense that, for example, if those orders require them to do certain things, go to rehab, undertake drug screening, is your sense that they feel that if they do those things, it might even make a difference?
Yes. And the other thing I think it's important to note is that we docket at Broadmeadows, which means once a parent comes to court, they'll get me every time they come back, or Miss Hawkins, which is really important, because if I say to the department, and I might say to the department, well, if the mother does this, this and this, will you return the child home? And so that puts pressure on the department, puts pressure on the mother, or accountability. So that it's not the case anymore where the mother might come back to court and has done this, comes before a different magistrate, and the department will change the rules and want the mother to do something extra. So the docketing's really important, and I think the fact that they see me the whole time and gain trust in me and Miss Hawkins respectively, I think that makes an enormous difference, because they're not getting a different magistrate each time. They're not being told different things. The other thing I wanted to mention in that regard was Noogle, and I don't know whether you've been told about Noogle, but they make an enormous difference to our court. Noogle are a part of VACA that have been, under Section 18 of our Act, assigned the duties or the responsibility of the department. So it's an Aboriginal organisation in charge of Aboriginal children, and they are fantastic. And the great results we get in Marama Ngala Gambu are more often than not cases that are managed by Noogle. And it would be terrific to see statewide a whole lot of Marama Ngala Gambus, a whole lot of Noogles, which means that Aboriginal people are dealing with Aboriginal children, apart from the magistrates. And I would like to think that there might be some more magistrates coming through that are Aboriginal men or women.
Can I just add to that too, in the case plan decisions through Section 18, they're Aboriginal people making them decisions about connection to culture and weighing up the risk of no connection to family and community versus the risk of harm. And the Section 18 stuff, the cases we made care by secretary orders in 2016-17 are now returning to court under case management of Section 18 to be converted to either family preservation orders, so children return to a parent, or to straight withdrawals from any engagement. So we've made in Marama Ngala Gambu with parents the decision to make a care by secretary order. The family have been not happy, but accept that that's where they're at. Case management is transferred to an Aboriginal organisation who work with them in the short term, assess the risk as acceptable, and they're returning children home. And because the mob know they're going to get supported through court, they're more than happy to pop back up. Even if the case plan is non-reunification, they know their voices are going to be heard, and they rock up to court. We go through the process and we're able to return children home. I just wanted to really highlight that.
Mr Morris, the evaluation found that with Maram Ngala Gambu there was greater compliance with the Aboriginal child placement principle, which is otherwise not being well adhered to in courts across Victoria. What results have you had with that?
I think that really important for you to hear about identification of matters involving Aboriginal children. Maram Ngala Gambu isn't a specialist court or a division of the court like the Koori Court or the Family Drug Treatment Court. It's just the way we want to deal with Aboriginal families because of the Koori-centred approach and the case management that comes from the court with docketing. So before we started Maram Ngala Gambu in both Shepparton and Broadmeadows, we had a high number of children who the court just didn't know whether they were Aboriginal or not. When the application was brought to court, there was no information that said this is an Aboriginal child, a Torres Strait Islander child, both, or neither. We had a big number of unknowns. And in Shepparton particularly, we had 57% unknown or not entered whether or not the child was Aboriginal. So our magistrates are getting the file with no trigger point to ask the question, does this placement comply with the Aboriginal child placement principle? And since we employed Tina up there in Shepparton, for the last 2 years, we've had that number below 1%. We've worked with our registrars to accept applications with it unfilled out, but not call it until we know. So our registrars, non-Aboriginal people, are asking the department while initiating, is this an Aboriginal child? If not, can you find out? If not, I'll call the parent to the counter and ask them myself. Put it on there, note it on the file, so our decision maker knows it's an Aboriginal child and the placement principles apply. And without Maram Ngala Gambu, that early identification in the court process wouldn't be there.
And does that mean that those children were also not being identified as Aboriginal by the department?
Yeah, the applications are brought by the department. So if they're not putting it on the form to initiate it, it's pretty safe to guess that
they don't know as well. So that
we do. I do want to add though, matters aren't coming to court for good reasons. There is time pressures on the department. In the middle of the night, the parents may not be around, the child may be too young to answer. I do want to acknowledge that, but I mean, if it's coming to court, we need to know because in our Act, the child placement principle applies.
So all the protections that the Parliament intended apply to Aboriginal children are not being provided if steps aren't taken to identify children as Aboriginal.
And I think it goes beyond Parliament too. Our community fought pretty hard for child placement principle to fit into their law system, and it just gets ignored.
Your Honour, Maram Ngala Gambu, as I understand it, can only deal with uncontested matters. Why is it limited in that way?
I don't know why it's limited in that way. We don't have many contests. At Broadmeadows, we do have this less adversarial approach of doing things, and we don't have many contested hearings, unlike the other children's courts. I think if it's a contested hearing, it was thought, and I can't really remember, Ash, why we thought. I think we thought that given a contested hearing was more adversarial, it wasn't appropriate to have it at the bar table like it is. But as I said, I can only remember one contested hearing we've had for an Aboriginal family in the last 2 or 3 years. So most of them settle.
Can I add to that too? Sorry, another reason we don't want contested matters in this space is because we want it to be family-led. We want the family to come up with reunification plans and reasons for adjournment to better support family. That's another reason why we don't hear the contested matters. And as Ms McPherson said, we rarely hear contested matters, and when we do, they don't run for the full period.
Ms Morris, there are 5 case studies in the outline of evidence that you've provided. I wonder if you would step through those and feel free to refer to that outline just to give the commissioners a sense of the work you're doing.
Thank you. Coming up with case studies is really easy because we have really good outcomes. So I'm going to talk about 5, and Ms McPherson's going to give you 2 bonus ones, but we've supported, over 800 families, and every one of them could be a good practice case study, regardless of the outcome. So the first one, and I will just read from my notes if that's okay. Otherwise I'll say something wrong. So after a period in out-of-home care, 3 or 4 children returned to their mother's care. However, one of the other siblings remained in out-of-home care. The parent had wonderful, regular, meaningful contact with the child, and it was heading down the contest route. Through Maramnala Gumbu, the parent was supported by the whole team, magistrate, department practice leader, and the Maramnala Gumbu crew family support team to get the parent in at the bar table and have their voice heard. It was quite emotional in court, and things weren't going anywhere in the court, so we stood it down. And we went into a breakout room with the department and the parent, and we said, this, we need to hear your voice. What is your issue? If you need a minute, let us know and we'll give you that minute. So we ended up adjourning it, and we went to a care team meeting with Mum. Mum was supported by a VACA support worker, and the Maramnala Gumbu team, as well as the child protection practice leader. Mum was empowered to ask the question, why do I have 3 but not my 4th home? What is the issue? To which the department responded, there is no protective concern. It's the young person's health needs that are being met in his current placement, so we don't want to remove him. This kid was in a non-Aboriginal placement and quite a distance from Mum. At the next court event, we were able to give Mum's voice the stage before the decision maker to say, I've got the department telling me there's no protective concerns, but why is my child in out-of-home care when I have my other 3? And it came out through the process that the NDIS package was attached to the carer, not the mother. The question was asked of, I think it was Her Honour, please explain, basically, what is going on right now? Why are we in this court with no protective concern, but for it being the child's medical needs? So we adjourned it and asked NDIS to come to court with a briefing as to why we couldn't support the mum. When we come back to court, the matter was mentioned regularly to keep things on foot whilst giving mum the venue or the voice to say, oh, mum, literally, please explain. And we're able to make a family preservation order and return that child home through the case management approach of Maramnala Gumbu. Had we not have had Maramnala Gumbu, I'm not sure that child would have ever returned home. There was no accountability held to mum, the department or the support sector to having this child returned home. And we were able to return that child home with his siblings and mum. Case study 2. This is a large sibling group of 6 children. Now, in the family division, there's a protection application by emergency care, which is immediate removal and straight to court within, is it 48 hours or something? Or there's a protection application by notice, which is, we've got some concerns, there's no need to remove, but we want to get it on the hop, basically. So the department, Preston office, worked with the Maramnala Gumbu team to make sure that the return of the protection application notice was in Maramnala Gumbu. So the first mention was in a culturally appropriate space where the case management of the file knew what to expect. They were experiencing homelessness and been couch surfing with friends, living in their car, and there were some unconfirmed reports of family violence. All while this was happening, all 6 children were attending school. I think actually one of them wasn't in school because they weren't of age, which is pretty phenomenal, the strength that family had to get through that, living out of a car with 6 kids to be able to get kids to school with no other concerns other than proven reports. The department wanted to withdraw on this case because homelessness isn't a protective concern. But due to the nature of Marumnala Gumbi, we just didn't allow them, and we just kept adjourning it monthly to wait till these kids had a home.
Well, the problem was the department were paying for accommodation in a motel, and they didn't want to fund it anymore. And I wouldn't let them withdraw until such time as the family found housing. I wasn't going to have them being turfed on the street. Sorry, I couldn't.
You're right. Thank you. We dragged it out for 13 months through Marumnala Gumbi, and once we found accommodation, a family preservation order was made. The kids were in the parents' care for a short period of time, and we never seen them come back to court. Had that have been in the mainstream, I don't even want to think about what could have happened. The next one talks about Koori-designed, Koori-led and Koori-delivered services in the court environment. A young couple had recently relocated from New South Wales and 36 weeks pregnant. There's an extensive list of protective concerns, and that's what brought the application to court. What the department didn't know is the family had been actively engaging in local ACCO since returning to Melbourne, who offered a much more holistic and comprehensive level of support, which was detailed to the court through support letters, verbal updates, and attendance in court. The local ACCO knew the family from previous involvement as the parents were involved in child protection themselves. Some of the staff in the Koori orgs had worked with the family for over 5 years, intergenerationally. So they had a well-rounded view. That's what Koori orgs bring to this space. We know how to support our families and give them the voice. And when we come to Marumnala Gumbi, we heard the stories of what support was on offer to the family and how we could keep the mob together. The beauty of Marumnala Gumbi, we have Lakijika Access at the table, who heard this. We stood it down, a consult was done, and Lakijika reassessed their position and supported reunification. The baby was returned to parents' care after spending a short time in out-of-home care, thanks to Koori-led, Koori-designed and Koori-delivered services. The next one's about Section 18. Again, the bar table was full of Aboriginal people, from Aboriginal services, Aboriginal family. The only non-Aboriginal person in the case was the lawyers and the magistrate. Just reading to catch up, sorry. So this child had been in non-Aboriginal kinship placement for a period of 6 years, which broke down to the father's heightened risk when he moved into the kinship placement with the child. During this time, the child was placed on a care by secretary order, so in the care of the department with a non-reunification case plan. The case was then transferred to Noogle. This is rewritten, so I'm just trying to reread it, sorry. The case was transferred to the Noogle program, and the parents were reassessed given the concerns of the kinship placement, where it just was unsafe for that young child. The parents were found to be suitable, and intensive supports were put in place by a number of VACA programs under the reunification case plan decisions by an Aboriginal person in Section 18. The matter was finalised on a family preservation order, which has since expired, and the matter has not returned to court. I know I've jumbled that up, sorry, Commissioners, but the importance I'm trying to highlight is if Aboriginal family are looking after Aboriginal people in an Aboriginal court, we get Aboriginal outcomes and kids are returned home. The final case study is a really quick one, and it looks like this one isn't too far from what I did write to present to you guys today. August the 3rd, 2021, Marumnala Gumbi and Broadmeadows. We had 4 care by secretary orders, so kids in the care of the department, all converted to family preservation orders. That's children return home. 3 of these matters were case managed by VACA's Noogle program, Section 18. Again, Aboriginal mob looking after Aboriginal mob. One of the cases, a 15-year-old boy being cased on a care by secretary order in 2009, and then again a long-term care order in 2015. The family preservation order was made for him to return to live with his father. The reason I wanted to highlight this one is that for some reason, Section 18 view fathers in a different light to the department. The amount of kids return home to parental care on the father side is seen nowhere else other than Section 18. The other one was a 15-year-old boy who was placed in a care by secretary order. Oh, sorry, reading the same one. Another case was a 12-year-old boy placed on a care by secretary order in 2017. That care by secretary order was made in Marramnella Gumbo. And I remember that day because the mum thanked us for putting her kid in a care by secretary order. And we were all in tears. We were all, why are you saying thank you? And she said it's because we give her a fair go and we helped her make that decision. She was happy with where the child was placed. She was able to work with the department in Marramnella Gumbo to assure her that that child wouldn't be removed and put in a resi care. And that's how we got her to agree. That's how she formulated the view to agree to a child care by secretary order. Now, a couple of years later, on that day in 2012, a family preservation order was made back to the mother, who agreed to a care by secretary order in our court a couple of years earlier. And the reason this happened is because case management transferred from the department to VACA's Noogle program. Their view on family forever is different to a care by secretary order that is renewed every 2 years. Even though it's a non-reunification case plan, like I said, Section 18 still view it as family forever and must maintain that connection. Regardless of where their placement or parental care lies, Section 18 tied up with Marramnella Gumbo are making sure that kids know who they are, where they're from, where they fit in, where they belong.
Can I just add there that when a child's on a care by secretary order, which means the parents lose all parental rights, in my experience, the department don't ever reconsider reunification. Once a child's on a care by secretary order, unless something extraordinary happens, they'll just apply for an extension after the 2 years. Noogle, on the other hand, will work with the parents and try and get the child home, and that's a really big difference. And that's why we have children being returned home on care by after being on care by secretary orders with Noogle. And I don't want to criticise the department because I know they're very busy, they're short-staffed, etc., but it just makes such a difference for Aboriginal children to be under Noogle's banner.
Thank you. And the last two, two children, 10 and 8, on care by secretary orders, which were made in 2019, again in Marramnella Gumbo. Since the making of that care by secretary order, the Marramnella Gumbo team still supported that mother and were able to get her into Odyssey House, which is a residential rehab. That mother was also a member of the Stolen Generation. She was forcibly removed herself. She spent the hard yards in Odyssey House and were able to have her children live with her in Odyssey House to complete her recovery. She was the first Aboriginal mother to reach the Leavers program at Odyssey House, something she was very proud of. And through her healing journey with her children, supporting her, yes, they were young, but having them close and access, reachable, she was able to do well in her recovery, and a care by secretary order was withdrawn and a family preservation order made. That again was a Noogle case. And the last one on that day was a department case where we had supported the mum through the process to continue showing up. Even though the care by secretary orders were made, mum still rocked up because she wanted her voice heard. It wasn't court active, but she popped up to the support team in Marramnella Gumbo to ask, what do I need to do? What have I got to do? Prior to Marramnella Gumbo, that mum would have been told it's on a care by secretary order, wait 2 years and then you can have your say when it's extended or not. Through Marramnella Gumbo, we're able to support that mum even while it wasn't court active to get her kids returned home. And I'll throw it over to Ms McPherson for her to...
All right, thank you. my colleague typed this out, but I know this woman very well. In fact, she came to our drug court Christmas party yesterday and is looking $1 million. But she was the mother of 3 children. She had a 19-year history of alcohol and drug use, and she had 2 older children removed from her care years ago and hadn't had them in her care. In February of 2021, she gave birth to a little baby girl, and this little girl was born testing positive for cannabis and ice. The department attempted to assist her on a voluntary basis to remain with her baby in a rehab facility, but brought the matter back to court when that didn't work. The matter then came into Marinala Gumbu, and together, Marinala Gumbu and the Family Drug Treatment Court, she was referred to the Family Drug Treatment Court, and she did absolutely brilliantly in that court. She participated in drug court as well as hearings in Marinala Gumbu. Her attendance record was exemplary, and she shared her experiences and her journey through recovery with others on the program. She had an enormous, lengthy history of substance abuse, but she graduated from the Family Drug Treatment Court, and she got this little baby girl back just before her first birthday. The court made a family preservation order, and not only that, but she's now got frequent overnight contacts with her 2 older children. In fact, one of her older children is in her care, and the other one's likely to return soon. This reunification was due to the mother's strong commitment to her children, but also was assisted by the very supportive environment of both Marinala Gumbu and the drug court at Broadmeadows. And as I said, I saw her yesterday and she looked so well and so happy. She had a little baby with her and one of her older boys with her, and it's just wonderful to see. This is another Aboriginal woman, the mother of 2 children, and she also had a lengthy history of substance abuse issues. Her oldest child was removed from her care about 17 years ago and placed with family members. Her youngest was placed, came to court when he was 2.5 years ago by emergency care as a result of her substance use and other issues. He was placed with suitable people over the next 2 years on interim orders and then a family reunification order, which obviously meant he wasn't in her care. This woman was also encouraged to participate in family drug treatment court, but ultimately didn't. A care by secretary order was made in mid-2009, removing her parental rights as she seemed to be going nowhere with her recovery. In July 21, a case plan meeting was held and it was determined that a permanent care assessment would commence. The case plan was non-reunification and for this little boy to be in the permanent care of his carer. Soon after that, and with the support of VACA and her care team, as well as the child's carer, she made a decision to make a concerted effort to get this little boy back in her care. She attended almost all meetings and court hearings from there on, and she had been drug-free for some time, but continued to do screens to prove that. Little by little, and with support, she was able to have unsupervised contact. And in November 2002, over 5 years after he was removed, this child was returned to her care. We magistrates in Marinala Gumbu were thrilled to be able to make a family preservation order for them to be in her mother's care. My colleague writes here that there was not a dry eye in the court that day, including all of her support workers, Marinala Gumbu staff and the magistrate, who was Miss Hawkins, obviously. On leaving the court, Miss Hawkins wished the mother and the child the very best and said that it had been one of the greatest pleasures to meet her and watch her determination to stay drug-free and be the wonderful mother that she is. This mother thanked the court and said that she would miss coming to Marinala Gumbu. And Miss Hawkins has written, "This is why we get up and come to court every day." And she's quite right. This court and drug court are the reason why I'm still a magistrate, because they mean such a lot to me, because we can do such good work with these parents.
Your Honour, I'm loath to ask my next question because it is an incredibly dry question. I just wanted to move very briefly and just talk about some of the practical issues with child protection proceedings generally. And I've undertaken not to ask your opinion about the law that you need to apply every day because obviously as a member of the judiciary you apply the laws that the Parliament sees fit to write. But I thought I could use your practical experience just to touch on some of the how these laws are applied in practice. One of the tests you need to apply is that of unacceptable risk. And obviously the word unacceptable does a lot of work.
Yes.
And the Act does not provide any criteria by which what is acceptable and what is not acceptable is to be judged, does it?
No, it doesn't.
Some of the case law on unacceptable risk in, for example, the bail context indicates that whether a particular risk is acceptable must be viewed in light of all the circumstances and that those circumstances could render acceptable a level of risk which in other circumstances would be unacceptable. Is that also the way that phrase is understood in your court, that what is acceptable in one context may be unacceptable in another, that it's not an objective issue?
Well, I think it's a very subjective issue as to what's an unacceptable risk or not. But often unacceptable risk can be ameliorated by things happening. For example, if parents have got problems, sometimes the risk can be ameliorated by a family member living with them to make sure that the children are looked after. But at the end of the day, it is a subjective, and it's a subjective thing, and we're all people, and we all look at things in a different way. The one thing I will say about Marinala Gumbu is that sometimes I've been criticised for finding that the risk is acceptable, taking into account a child's Aboriginality. And I accept that criticism, but I will still continue to do things the way I do because I think what some people don't consider is the risk of a child losing their identity by going to a non-Aboriginal family. And there simply aren't enough Aboriginal carers. So if you don't send a child home, that is part of the assessment of risk in determining whether or not there is risk. You've also got to take into account the risk of the child being placed in a non-Aboriginal family. And my experience is once they're placed in a non-Aboriginal family, that can go on for years. And if a child loses his or her cultural identity, that is a real risk. And that's something that needs to be taken into account.
And, Your Honour, although you take that into account, there is no requirement in the legislation when considering unacceptable risk for a magistrate to consider that removal may result in loss of culture, loss of connection to community.
No, there's nothing in the Act in relation to acceptable risk. I mean, there are the Aboriginal placement principles, and we have to take those into account. But there's no specific legislation in relation to the definition of unacceptable risk.
Yes, and I'm thinking of, for example, sorry.
Do you think that the approach that you've explained as the preferred approach is strongly enough supported in the legislation to give you comfort as a judge for doing the right thing?
Well, I think it is. I mean, I don't believe that I'm going outside the Act in doing what I do, but I think it's a little bit racist for people that criticise me to say that I take a child's cultural identity too much into account, because I think a lot of time the department don't take that into account. They don't consider it important. That's why I say that I think they're a little bit racist, not intentionally, of course, but that's my view. I don't think I'm doing anything illegal or contrary to the legislation.
Yes, I was thinking when you were speaking about the Bail Act in particular, there are those requirements in the Bail Act, Section 3A, to require consideration of culture expressly in making bail decisions. And next week we will be hearing about those bail laws.
Well, that's a great provision. That's all I'll say about that.
Yes. I think it's within the separation of powers for you to speak with approval of the laws that are in existence. To the extent that, to what extent are children's court magistrates talking about this risk assessment or assessment of what's acceptable and unacceptable and the nature of the risk for a child, to what extent are you presented with detailed information about the risks associated with child removal, the ability of the secretary to be a good parent to that child, or the likelihood of them ending up in juvenile justice if they go into out-of-home care, or the rates of suicide and self-harm amongst children who are removed. So when you have to apply this test of unacceptable risk, are you given information on both sides of that ledger?
No, generally not. Generally not.
So is it fair to say that magistrates are being asked to assess unacceptable risk when they're being given a lot of information about the risks in the home, but not on the other side of the ledger?
Yes, very rarely do we get any information about risks on the other side of the ledger.
I have no further questions for these witnesses. Are there matters that the Commissioners, additional matters the Commissioners wish to raise?
I've got one, at least. We heard evidence this morning from Aboriginal people working in organisations providing early childhood development services of various kinds, including childcare, but much wider than that, who know the kids really well and who probably know the kids better than anybody other than their parents and their immediate family, certainly better than the department. And yet they're not called upon by the department to provide information about the child and how they're going. And I'm wondering about whether you have any interaction at the court with such people, the early childhood development sector.
So the whole sort of ethos of Maramnala Gumbu is get the right people in the room. So that falls on my team to get them into the courtroom. If we can't get them there because they're very busy people, we'll get them to submit, letters of support, or get their lawyers in contact with them, and they can make submissions from the bar table. So we really want we run out of chairs all the time in Maramnala Gumbu, particularly pre-COVID, because we had everyone in the courtroom there to provide that update. And often, if we couldn't get them there and we couldn't get support letters, we would do a short adjournment, an adjournment for 2 weeks to get that person in on a date that suits them. So we do, in Maramnala Gumbu, hear from them, and it sort of then opens up to a bunch of other short adjournments because the department need to reassess because we're just hearing this information from now, and that's what we set up Maramnala Gumbu for, to get the whole story and the whole picture.
And we've been to Bubba Willem, and it's an absolutely fantastic kindergarten. And when we had our official opening, can I have that photo again of the court? There's a beautiful picture done by the Bubba William children of the Aboriginal flag done with buttons, and that's on the wall. Oh, you probably can't see it, and that's on the wall. And I love looking at that. And the children came along on the day and did a dance for the opening of the court. No, you can't see it, unfortunately. But yes, we do value their voice.
I'm just wondering, and you may not know the figures at all, but with Shepparton and now that Rumbalara's transitioning over to Section 18, or they're half authorised, can't remember the correct wording, have you seen a difference up there of the engagement? Or
We like Broadmeadows, we get Rumballara to the court, and we've had countless cases where we've avoided children going into out-of-home care or residential placements thanks to Rumballara and their knowledge of community. And that's all in court at the bar table. So they're not necessarily engaged with the family, but they can see us from the gallery fumbling to avoid having to order this child to go to out-of-home care or a residential placement. And because of the nature of court, Rumba are able to just stick their hand up and say, "Can you give me a minute? Can we stand down?" They'll say good day to mum and dad out the front. I know this, I know that, because we're all community people. Run it by the department, get it back in, and we've been able to avoid kids going into out-of-home care thanks to Rumballara. And I think, I forget their names, but Tenor King's here today from Shepparton, who I know isn't a witness, but would be well across the support that Rumballara offer. And like Ms McPherson said, we're really hanging out for Section 18 to be at that location, because we know through VACA's work with Section 18 and what Rumba already offer the court in decision making without being a case decision planner is unreal. So really hoping for that.
And can I ask either of you, do you feel that you are holding the department to account for these children
very
and
much
families?
so. Very much so.
I think to add to, we hold the family to account as well. I think it's really important to know that our best cases are when we've said nothing and we've had the elders come in and just rip their mob and say, I didn't fight for you to be doing this to your kids. You know, we've got nans and grandparents in court saying, I raised you because your mum couldn't, and we want you to be a strong Aboriginal person, and this is your opportunity. You've got the decision maker in front of you, you've got the support of your family. Let's get you through this.
Because we've heard from previous witnesses about racist reports or reports that aren't accurate. I guess that's probably a better way to put it. And you see those reports, are they questioned and gone through with the family? And are they gone through at the table with the department and the family, or?
Well, we don't actually go through the reports, but if the family say that a matter's been misreported, well, we'll say to them, well, what's your side of the story? What do you say in relation to this? And I'm not going to accept what the department says willy-nilly, because, as I said initially, they don't always have all the information. And that's why it's important that the parents be there to be able to tell me that, so I know that there's another side to the story. Whereas before I was just in a void.
And in the lead up to court, it's my team's role to make sure that the court reports are handed in on time, that they're provided to the lawyers, that the parents have it, and that they're aware of what's written in it. And I think through this whole session, we've sort of not really touched on our child protection practice leaders, who are there to do what we do with the family, but with the department. So they're in the back line, checking up, hey, this is due next week. I see you haven't started the report. Make sure it's due on this date. And if not, we can, reach out to the Marramnella Gumbo team and see if we can do a short form update so we can still progress the matter, as opposed to adjourning for 3 weeks just for a report. And the department's practice leaders, extensive knowledge in the field and are just as important to the process as what my team is.
Can I just ask, how many workers are in the program?
So in Broadmeadows, we're lucky enough to have a career service coordinator whose role is to manage the list. So they're making sure that we can hear what we've got listed on that day. There's no point putting 10 cases that need 2 hours in a day where we only have court for 4, as well as dragging the services in and building that relationship to get them in the door. In Broadmeadows, we have a career family support officer whose role is purely just to support them through the process. And generally, we will, if there's no referrals in place and they're coming unsupported, we'll, I don't know how to say it other than hold their hand until we find the most appropriate service and send them off to them. Unfortunately, we didn't receive the funding we would have liked for Shepparton, so we only have one career service coordinator up there and no career family support officer. And that's because our data was so unreliable. We had 57 unknown and 23% we knew were Aboriginal, but once we bring that down to 0, it actually put our numbers up to about 42% of the list up in Shepparton to be of Aboriginal children. And then we've got the practice leaders in both locations, and they're shared across both the Family Drug Treatment Court and Marramnella Gumbo. Lakijika are like a foster brother to the court. They provide us a worker when they can. Victorian Aboriginal Legal Service and JIRA used to provide us a duty legal service. And I'm sure you have heard this week and next week about how poorly resourced they are for the most jailed and removed children in the world. We just couldn't chew up their time without them getting referrals. So, again, to talk in terms of the business we deal with, they're our foster brothers and sisters. They're part of the team, but they're not, crucial to it. And you'll see in our evaluation, one of the key recommendations in expansion is that the local service providers be adequately funded to deliver a Maramrala Gumbu in their area, which is really tricky for us as a team to support. But we hope that when we do get expansion, it's not just for the court, it's for Section 18s and supporting the local ACOs to be ready for that, as well as leakage access programs and support services.
Thank you. Thanks.
Just a quick, is expansion on the cards?
If we can get funding.
Okay. So where is the funding located? Where's the...
At the moment, half of Broadmeadows is funded by the Children's Court, and Shepparton and Broadmeadows are funded under the Aboriginal Justice Agreement, and the department self-fund their practice leaders. I'm not...
As precarious? Is funding precarious?
That's too big a word for me, sorry, Commissioner.
Is it shaky?
Oh, no, it's not shaky, it's just not there. Yeah, so...
We've got funding for Broadmeadows and Shepparton, but we'd like Marinala Gumbu in every court around the state, and that we haven't got funding for.
We don't, the court don't see it as a specialist program, it's just the way we deal with Aboriginal families. And pre-COVID, Miss McPherson and Miss Hawkins ran Maramrala Gumbu for all matters. And, you know, I hope it might, I don't know if I'm even allowed to say this, is that it's just how a Koori-led process becomes the new way of doing things, because it's achieving better outcomes for all Victorians, but importantly, you know, reflecting back on Koori ways of doing things. You know, we've been around for far longer than any child protection system, and you know, I'd love to see what we set up, us two and others in the early days, being the way we deal with child protection matters across the board, because we know it works for everyone, starting with an Aboriginal-led, Aboriginal-designed process.
I've just got one more question, sorry. Actually, this just come up as I was thinking about funding. You can get funding, but can you replicate Ms McPherson and Ms Hawkins? Like, can you find that those qualities?
I think so. I think we will be able to. We need to bottle Ash and put him in every another Ash in every region. But yes, I think we will be able to find enough people that are interested in doing things a different way and getting these better outcomes. I do think we'll be able to do that.
It's in our evaluation that the successes of the program have been the people in it, and I often get, you know, the accolades because I was there first, but we've had some really fantastic people around us, and if I can name them, we had Elisa Buggy, who basically opened the door for Miss McPherson and I to do what needed to be done, who was replaced by Pete Lamb. Again, doesn't get involved unless I can't get it done myself. We had Marie Segal, she's here today. She was our first Koori Family Support Officer. You know, without Marie's input in the early days, it wouldn't be what it is today, just with her experience in the child protection sector. Who else? Matt Wilson, our first child protection practice leader, and even Nathan Chapman from the department. I mean, we've had some fun times with Nathan, but you know, without him, we wouldn't have been able to get Matt for that initial 6 weeks, and then Matt set up from the department's perspective what that practice leader should look like, which then led to the employment of Karen Lloyd and Kayleen up in Shepparton as practice leaders. In Broady, we're currently running a vacancy, but we had Ash Moffat and Kristen Bell, you know, two strong Koori women that really advocated for their community to get the best outcome. So it's nice to be acknowledged as, you know, the running joke is that I'm the founder and they call me the founder, but really it's them doing the work, and I wanted to acknowledge them through this, everyone that's been involved, yeah.
Can I just ask one quick question, and that is, you referred to the involvement of elders at the table before. Is it like the Koori Court where that always happens, or was that because of the family setting?
Yeah, because it's pre-proof, we couldn't have non-party members influencing the outcome.
Yeah.
So we quickly come up with the bring your own elders. So it's my team's role to be ringing everyone with the permission of the parents to say, hey, if you can, we'd love to have you here to have input to your family's life. We recently had Annie Pam Pedersen, who was on our steering committee up in Shepparton. She popped out to give us some hints and tips on how we can get elders involved. But it's a really tricky situation in the pre-proof space. We don't want to prevent natural justice. So it's one of the many to-do things to do on my list. We're comfortable with the way we involve elders at the moment, but some parents are removed themselves and don't have that connection to their elder, and it'd be great to link them back up to their identity through this process that was taken from them through this process prior.
Could I say one more thing? I know time's getting on. I don't know whether you've got a copy of our evaluation, but if you have, I'd really like you to read it. It's a matter for you, of course. But as a non-Aboriginal person, when Ash and I set up this court, I was very mindful of the fact that I didn't want it to be paternalistic. I didn't want it to be seen as we white people, again, telling Aboriginal people what to do. And when I read this report that's with the comments made by people that had come to the court, I was absolutely blown away, because all I wanted was for Aboriginal people to feel comfortable coming into our court and to get better outcomes for Aboriginal children. And I mean, this is one quote: "I feel confident every single time I walk in there. I can say what I feel in Koori Court. You have an opportunity to sit around and get a chance to get to the bottom." And another person said, "You walk through that door and your spirits just lift up, basically, and a smile comes to your teeth." For me to read that an Aboriginal person says that about coming into court was just fabulous. And it was as a result of this evaluation that Ms Hawkins and I decided to try and do the same model with all cases at Broadmeadows. Unfortunately, COVID intervened and we haven't been able to get back to it, but we will in due course. But, you know, I'm so proud of what has been set up and the outcomes that we're achieving.
Thank you.
Thank you.
And that is Annexure 1.
It's Annexure 1, so it's in
That's it.
evidence. By all cases, you mean all cases Aboriginal and other?
Yeah.
Across the board?
Across the board.
Yep.
Yeah. Because the fact that the parents get to have a say is, I think, is important for all people, whether they're Aboriginal or not. Thank you very much for listening to me.
I will, Chair, now tender into evidence the outline of evidence of Magistrate Kay McPherson and Ashley Morris, and Annexure 1 to that is the evaluation, and Annexure 2 are those photos that we saw.
They'll be entered into the next exhibit numbers. Thank you, Councillor.
Thank you. Thank you, Your Honour, and Mr Morris. It was wonderful to hear about the work you're doing. We've now concluded today's evidence.
Thank you. Thank you very much.
Thank
Nice
you.
note to end on. Thank you.
Yes, thank you.
Thank you.